a license within Section 7, we propose the following amendments for fairness, clarity, and ensuring checks and balances. With regard to Section 7, subsection 3, we propose deleting the period from the date of notification of the decision to within 90 days of receipt of the notification of the decision from the central bank for review of a determination. Additionally, we propose amending subsection 4. In considering an application for review under subsection 3, the central bank may, deleting consider and replacing it with take into account any relevant information, including material events, and deleting that occurred and substituting with occurring after the central bank made its decision. And in subsection 5, the central bank may reserve its decision in subsection 1 if deleting it establishes that the information provided by the applicant addresses the reason for refusal, and substituting it with is satisfied that the applicant has provided information that adequately addresses the reasons for refusal. Additionally, we propose inserting subsection 6, which would provide that the central bank does not reserve its decision under subsection 1 because it is not satisfied that, if the central bank does not reserve its decision under subsection 1 because it is not satisfied that the applicant has provided adequate information to address the reason for refusal, the aggrieved applicant may, under subsection 6, appeal to the Cabinet Secretary within 14 days. In section 6, we've proposed amending the definition for classes of microfinance business. Section 8 empowers the central bank to prescribe different requirements for institutions relating to licensing, operating fees, and payable reporting obligations or any other matters that the central bank may deem necessary. Section 8 then goes on to empower the central bank, Section 8 goes on to empower the central bank to direct that certain provisions of the Act shall not apply to a category or of institution if the nature, mode, or place of business renders the application of those provisions unnecessary. We propose the following amendments in Section 8, subsection 2, that the central bank may, by regulations, direct that removing certain and replacing it with specified operational and administrative provisions of this Act shall not apply to and removing certain defined categories of institutions if the nature, scale, inserted, mode or place of business of that category renders the application of such provisions unnecessary or disproportionate as inserted, and subsequently inserting, provided that the central bank shall not display any provision of this Act relating to the prohibition on conducting microfinance business without a license, minimum capital and prudential requirements, consumer protection obligations, governance and fit and proper requirements, or supervisory inspection, investigation, and enforcement by the central bank.
Shall pick up page 11 from section 9, still on part 2. And this is with respect to the central bank's power to examine. So we are proposing amendments which are geared towards balancing the CBK's need to act decisively to protect depositors and the public against unlawful microfinance activity, whilst embedding safeguards for the rights of those being investigated. So to achieve this, we are proposing a proviso just after subsection 1 of section 9 that reads as follows. So CBK may enter any premises and examine the books, accounts, records, equipment, computer systems, etc., provided that where the premises to be entered are not the registered business premises of a licensed institution, the central bank shall first obtain a warrant from the High Court authorizing the entry and examination. Notwithstanding paragraph A, what I just read, where the central bank has reasonable grounds to believe that entry without a warrant is urgently necessary to prevent the destruction or concealment of evidence that may affect depositors or the public, then the central bank may enter without a warrant, but shall within 24 hours of so doing apply to a court of competent jurisdiction for an order confirming that entry. And then Part C, the warrant referred to in paragraph A, so the High Court warrant, should specify the premises to be entered, the nature of information or items sought, and the period within which the warrant may be executed. Then the entry shall ordinarily be conducted during ordinary working hours, unless there is urgency to do that otherwise. Then the central bank shall prepare a written record of the inspection and furnish a copy to all affected persons within 7 days. And lastly, any information that the central bank obtains in exercising in the exercise of its powers under Section 9 shall be treated as confidential and used solely for regulatory purposes under the Act. Moving on to Section 10, we are proposing amendments to introduce a show cause period on revocation. And in our view, revocation of a license is a consequential action that effectively terminates a business. It impacts staff employment and directly affects the deposits of thousands of customers. So due process therefore requires a sufficient and realistic response window. 28 days, which is the period currently provided under the bill, is in our view inadequate for complex representations involving financial, legal, and operational matters, whereas our proposed 45 days is more consistent with due process norms. And then the emergency suspension mechanism, we consider it essential for depositor protection, allowing CBK to act swiftly where immediate intervention is necessary to prevent harm, for example, in cases of fraud or imminent insolvency, while preserving procedural fairness in non-emergency, provided that where the central bank determines that an institution poses an imminent and serious threat to the interests of its depositors or the stability of the financial system, then it may immediately suspend the institution's license for a period not exceeding 30 days, pending completion of the show cause process. Section 11 on restriction on ownership of share capital, we are proposing an amendment, and the rationale for this is that the purpose of this section is to prevent excessive concentration of ownership in a single person, and without the clarification that we are proposing added to that particular section, this restriction will be bypassed by spreading shares among associates or related parties acting together or acting in concert. So including associates ensures that the 25% cap applies to both direct and indirect holdings. It closes loopholes and strengthens transparency and stability in the microfinance sector. So for the purposes of subsection 1, we are proposing that reference to person also include reference to that person's associates. Section 13 and the value would better reflect the different scale and risk profile of community-based microfinance banks compared to national institutions, and applying identical capital thresholds risks forcing smaller community microfinance banks to fold, thereby reducing financial inclusion in underserved areas. And then section 19 on provisions and declaration of dividends. So in our view, linking dividend payments to capital adequacy ensures institutions cannot erode their regulatory capital by distributing their profits prematurely. So the prohibition on dividends during corrective action plans, as we shall see in our amendment, prevents institutions from undermining regulatory remediation, while the broad certification requirement, promotes compliance discipline and personal accountability for directors and CFO, and provides the CBK with a structured early warning mechanism. So our proposed subsection 3 reads, notwithstanding subsection 1 above, no institution shall declare or pay any dividend where the payment of such dividend will cause the institution to breach its minimum capital requirements under section 13 in the first schedule, which I just read, and then the institution is operating under a corrective action plan, capital restoration plan, or supervisory direction issued by the central bank, or the institution is classified as undercapitalized or significantly undercapitalized within the meaning of the Act. And then a slight amendment to Section 21 on insider lending. So the proviso provided under Section 21, subsection 3A, we wish it amended to read as follows. So provided that in the case of an advance loan or credit facility to a person other than a director of the institution or a senior officer or significant shareholder, an officer, we are proposing the addition of a significant shareholder. So it will read an officer and significant shareholder. And our rationale for this is that significant shareholders should only be held liable where it is demonstrated that they directed, approved, procured, influenced, or knowingly acquiesced in the making of the contravening loan, advance, or credit facility. And this, in our view, preserves accountability for insider lending abuses while ensuring that liability is imposed fairly and proportionately on persons who are actually involved in the lending process. And then Section 23 on the participation of significant shareholder in senior management. So we are proposing the addition of the following new provisions. And our rationale is that significant shareholders may attempt to bypass the restriction by placing associates in executive roles, thereby exercising control through proxies, which undermines the purpose for separating ownership from management and protecting depositors from conflicts of interest. So defining senior management by explicit reference to key executive roles removes ambiguity and ensures that all critical decision makers fall within the restriction. So no significant shareholder of a microfinance bank or any associate shall, those are proposed additions, be an executive director or form part of the senior management of the institution or institution's non-operating holding company. And then for the purposes of this section, senior management consists of senior officers who are responsible and should be held accountable for overseeing the day-to-day management of the microfinance bank, and includes the CEO, the executive director, deputy CEO, general managers, chief risk officer, COO, CFO, secretary to the board, treasurer, chief internal auditor, or manager of a significant unit of an institution. And then to Section 31B, concerning exhibition and publication of audited accounts, our proposal is that the accounts are also published on the individual institution's official website. And then Section 36 on notification of new developments to the CBK. So we propose an amendment to that section to provide as follows: an institution shall, so strike off the phrase that begins with promptly and ends with requirement, so that Section 36 will instead read, an institution shall notify the central bank of the following within timeframes prescribed below. So any material adverse development, which includes breach of any legal or prudential requirement within 24 hours of the institution becoming aware, any cyber incident, data breach, or information security event that may compromise its systems or the personal data of its customers, proceedings instituted against that institution in any position within 48 hours, and then for purpose shall be as prescribed by the central bank by reference to specific financial thresholds and types of events. And then Part 7, Section 46, that relates to protection from liability. So we, in our view, immunizing CBK and its officers from liability for all acts and omissions, including misconduct, would effectively place CBK above the law and deny affected persons meaningful remedies. So we are proposing carve-outs, as I will shortly read, that seek to ensure accountability while still protecting CBK officers from vexatious litigation so they can perform their duties effectively. So our proposed addition is a proviso, so essentially a carve-out that reads, provided that the protection under this subsection shall not apply to 1, any act or omission involving gross negligence or willful misconduct. Secondly, any act or omission constituting a criminal offense under this act or any other written law. Thirdly, any act or omission that constitutes a violation of the fundamental rights and freedoms of any person under the Constitution of Kenya 2010. And lastly, any act or omission that falls outside the scope of the lawful authority of the central bank or the officer, employee, or other person concerned. So I'll just yield to my colleague to bring our proposed amendments to the microfinance bill to a close. Thank you, Chair.
So the last amendments to the microfinance bill relates to consumer protection provisions, and the second schedule lists out the competent authorities. So on consumer protection provisions, we are proposing to add additional measures that should not be taken by an institution against its depositors. And these include the prohibition of predatory lending practices, charging interest that are not disclosed in advance to the borrower, imposing charges that are not agreed upon in the loan contract, and using a third-party debt collectors who employ harassment or violence in recovery of debts, and accessing a borrower's mobile phone contact list for purposes of debt collection. And our proposed amendment to the second schedule. So this lists the various competent authorities such as the CBK, the CMA, the Financial Reporting Center, the Communications Authority of Kenya, RBA, and IRA. So we also want this second schedule to also include the Office of the Data Protection Commissioner, which is relevant because the bill contains provisions involving access to the borrower's personal data, and also the Competition Authority of Kenya, because it's the bill contains provisions on amalgamation and acquisitions, and also imposes consumer protection duties. That marks the close of our submissions on the microfinance bill.
Thank you very much for your observations and your presentation. So are there questions from members or concerns or clarifications? Maybe before CPA you go, FCPO, you'll introduce yourself.
Thank you, Chair. My name is Joseph Oyula, Member of Parliament for Butula and a member of this committee.
Asante Masibrito.
Thank you, Chair. Allow me to congratulate Anjawala and Kana. I think they have done in-depth scrutiny on this provision of the bill, and that is why they have made several proposals, and including new additional information. Allow me only to pick on the first part of their submission on clause 2. I'm sure whatever section 2 is clause 2 for the purpose of the bill. On definitions, the word associates. They are proposing to delete the word E and replace with third person. I wish to get to understand from your side. The draft of the bill chose the word E. Is it, and you are saying no, we need to delete to third person. So the two words, what is the weight of the two words? If it remains as E and you are changing to third person, what informed this? Are you looking at gender issue or for the purpose of legal provision? Why are you looking at this? But what is so sensitive that you are picking at this? Number 2, you are expanding family to include half brother, half sister, and grandparents, whereas the bill has left out these grandparents, grandchildren, half brother, half sister. Why are you opening up to grants? What is the relationship between, and also in the context of African setup, where we know generational distribution, and I'm sure I'm thinking far beyond on the issue of succession. How does succession relationship happens between the children, the parents, and the grants? Assuming by the time succession issue arises, the age of the grandparents and the children, the active parties on this. I really wish to know that one. Are we intending to influence any other law on succession? Because if we are putting on this one, will it affect the other treatment on existing other laws? When we introduce stepfather, stepmother, stepchildren, and here you are bringing the issue of who is half brother, who is half sister in this context, because we could be opening a Pandora box for conflicts in families in future succession story. I think that's my concern, Chair.
Anna Bomboni?
Yeah, Chair, I actually had the same concern with Honorable Ruto. I think this one, really, I don't even understand why you are trying to even bring stepfather. I mean, stepfather, stepmother, stepchild, really adopted, and grandchildren, grandparents. Some of them maybe is too old, even to conceptualize really what is happening. So I really don't understand that. And in-laws. Now you bring in-laws. I mean, we are done. For men, is terrible, because the daughter is there, the mother-in-law, the father-in-law. I mean, I don't understand. You need to tell us, really. But going to section 47, you are proposing that. Your proposal, and the shall take measures to ensure that existing and potential customers of e-service are adequately protected, and such measures shall include. Now, how will an institution make sure its customers are protected, both existing and potential? How? I mean, some companies have like 1 million. Like, for example, Safaricom, I don't know how many customers, Safaricom alone. 30 million. Yes, yes. How will Safaricom, for example, make sure that its customers are protected, the existing and the potential one? I mean, it's something which yeah. Okay, sir. Concerns.
Which definition of family to adopt? Is it the definition of family to adopt? Is it the definition of family as per the Capital Markets Act? And
as to what I was almost asking in terms of issues to do with lump summed plus the in-laws and everybody. So the definition of family is, I think, what I have an issue with. Yeah, especially in the African context. Family. Thank you.
So maybe, and as a response, if you have information on because I'm almost certain either the Finance Act of 2023 or 2022, we changed the definition of family in the Income Tax Act. You know, where we had now that son, daughter, who it may not be for this discussion,
Yeah.
but I think we may have to find a definition of family and become consistent, so that what is in the Capital Markets Act is the same as it is in the Microfinance Act, the same that is in Income Tax Act. We need to have a harmonized definition who is family in our laws in our country.
Yeah. I think in that we brought in the issue, defined the issue of families, but it was like the core family members. I don't think there was the issues to do with the stepfather. Yeah, the in-laws. Those are very dangerous people. Now, very dangerous. They can even go to court. But
Lamboni, if you have issues with your in-laws, not everyone has issues.
I need to remind Mbogi, I'm sure, the day you went for negotiation is quite long. You were told, Maria Imaliswangi, you don't finish dowry, so you pay perennially.
So over to you, respond to those. It's not an exam, so we're just picking your minds on it. If you have a response, yes, if you don't, it's fine.
Thank you, Chair and honorable members, for that feedback. So I'll start with your last sentiment with respect to the harmonization of the definition of the term family across our laws. It is one that we agree with. And also, as you rightly mentioned, this proposed definition of family has actually been lifted from another of our legislation. And what we're trying to do is to capture as many African realities as pertains family within the definition of the term associate, whilst understanding also the practical realities of how people tend to, distribute their investments, particularly through proxies, most of whom are, or some of whom may be a particular investor's associates. So the rationale really just borrows from our African family context. I mean, happy to take your feedback on in-laws, but this, to the best of our information as well as legal imagination, is what really does justice to expanding the broad limits of the term associate, especially in the context of family. And like I mentioned, I mean, it will be prudent, again, in the spirit of expanding the scope of associate in the context of family, to move, in addition to core family members. Again, if the intention is to broaden, then you're obviously looking beyond your core family members, so your spouse and your immediate family members, to just about anyone who you might have as a business associate, to defeat the intents and purposes of the Act. And then to the question by honorable member, that's you.
47. So I'm responding to your question on how an institution should take measures to ensure that the consumers are protected. So this is a provision that was proposed in the bill. So what we are proposing is to add more provisions on protection of the borrowers or the depositors. So for example, a microfinance institution can take measures. Let's say a depositor wants to take a loan. So before a depositor takes the loan, the microfinance institution should first explain the interest rates, the repayment terms, and the penalties, for example, in plain language to the depositor. And then we are also aware
Financial of a bank taking a loan. How will, when the bank itself want to exploit the customer? Bank taking a loan. How will, when the bank itself want to exploit the customer? Bank itself want to exploit the customer? Because I'm saying this because, I mean, if you want to with the very small prints. In need of the money, you end up
the bank.
There's a question I missed, Chair, if you allow me. Honorable member had asked why we had struck off he in the definition of associate under section 2. And our reasoning for that is obviously for gender neutrality. So there's no particular issue with the usage of he or she. We just want to keep the definition gender neutral. So that informed the deletion of he, and instead our proposed adoption of that person, which neutrally references male, female, and all genders. Yes, I think that are responses to your questions, honorable members.
Chairman, my question is on, so what do you propose? To solve if now they have issues, the microfinance institution has issues with the regulator, then what do you propose? Because you said 14 days appeal. Do you propose that an intermediary comes in to solve before they move to court? To solve any disputes arising from maybe if they were not given fair hearing.
Chair, while you are going that, I have some concerns here. I was going through your submission. Of course, I know Chair guided you to go straight to the proposals on the bill. But there are some notes you had printed prior to that, especially on your recommendations. I know the bill is touching, it's mentioning the deposit and non-deposit taking business. And I see you are proposing that this particular provision should be deleted. Probably so that it doesn't go without getting your wisdom. Why are you proposing to be deleted? Or as you know, we've done several amendments and have given power Central Bank of Kenya to oversight both the deposit taking financial institutions and oversight non-deposit taking financial institutions. As you've said, there are other regulations that are underway. Now, again, revisiting your objective, saying that there is a need to support the repealing of this, because this particular bill is repealing in totality the Microfinance Act. Reason why? Because of change in the business world. We have shifted, culture has changed, systems have changed, technology has changed. Chair, I remember we've been following up on a matter. There was a question raised by Honorable Munyoro sometimes back on the issue of buy now, pay later. I don't know, Chair, whether you still remember that matter, which is still hanging. Yes, a microfinance. They may not be but what they do, especially on motorbikes, customer goes, takes a motorbike, pays some deposit in more or less like a purchase system, and then pays over time. The total effective price of that, price. And the caps which have been existing is regulator on this. I think in the courts on this Shylock throughout. But who regulates it? I'm asking this here because probably those consumers are protected because they've been exploited. One, when they clarity on how to register that particular ownership. Sometimes they pay when they're about to finish. Certainly, the motorbike disappears. Or when you've paid even over and above. And then if you fail to meet on some installment, they repossess without cause. Where will that put? Probably from your wisdom. Because you say delete, and to my understanding, this would have protected them.
Okay.
And if there is any way, again, in definition, whether there is need to divine that particular business orientation in this particular bill. Thank you.
Thank you.
Maybe just to we're trying to talk with our Kelly here on the several definitions. And trying to understand what was the thinking of the drafters of the bill on the definition here. So the definition as proposed in the bill is a copy paste of definition of family as per the Banking Act. Now, what Anjawala and Kana are saying is the definition of family, they are lifting from the definition of family as per the Capital Markets Act. We are checking the Income Tax Act has a completely different definition of family. So even if maybe not for this legislation, we may have to consider this in future legislation to have a uniformity on definition of family. On the law of succession, again, it's different, but law of succession, you can say it's on a different matter because that is dependence. But I think for these other matters, for the sake of financial matters, our laws need to be consistent. True. I conclude. We have one more bill to go, and you have two more stakeholders to go.
Thank you. So we will respond to the honourable member's question on if we are proposing that all references to non-deposit taking businesses to be deleted from this act. Are we essentially just removing them from regulatory purview? And our response from our rationale, we are of the view that there is already an existing comprehensive regime, regulatory regime for non-deposit taking credit businesses. They are currently licensed and regulated under the Central Bank of Kenya Act, and there are draft regulations proposed again by the CBK as their regulator, making provisions on all manner of regulations for those particular businesses. So our reasoning is, if we introduce non-deposit taking businesses to a piece of legislation that focuses on microfinance banks, what we are effectively doing is we are creating a separate and unnecessary licensing requirement, because that's already there under the CBK Act and the draft regulations. And then if you look at the regulations, they provide that they apply to entities not otherwise regulated, and they expressly exclude entities licensed under the Microfinance Act, which is the act that we are repealing in totality if this bill were to be adopted. So all entities under the Microfinance Act are already excluded from CBK's regulation or definition of the term non-deposit taking credit businesses. I mean, so we should just we should be consistent with that. So we remove all references and mentions of non-deposit taking businesses from this legislation that primarily is geared towards or focused on microfinance banks, and leave them now to the CBK and the consequent regulation. So they they are regulated, just not neatly under this. There exists a comprehensive regulatory regime. Thank you. Okay. On the dispute, and if I recall, your question was whether it will be prudent to have intermediaries in the event that the issues adverse decisions against agencies. We just came from reviewing the proposed investment and export promotion bill. The current act already provides for a panel, and the direct answer for this, for purposes of the microfinance bill, references to the CS. So if you're disgruntled, if you're unhappy, you go to the CS. Just to improve our discussion under the bill and under the current investment promotion act, there's a creation of a panel. So whenever there is a grievance, the CS or the aggrieved party can request the CS to constitute a panel to look into that grievance. So perhaps maybe for value add, you may want to see, without prejudice obviously to our comments on that particular proposal in the bill, you may want to see whether such a framework will be beneficial for purposes of disputes and grievances under the microfinance bill. But there's already an avenue to the CS under the bill.
Honorable Chair, my name is George Peter Kaluma. I'm the MP for Homa Bay Town constituency, and I'm a member of this committee.
Hi, so we'll start with clause 2 of the bill and our proposed amendment to the definition of undertaking. Currently, the proposed amendment is that the definition of undertaking is extended to include the words natural person immediately after the words trade associate. So as currently drafted, the extension to natural person has no limiting language. Without a qualifier, any individual, including an employee or consumer, acting privately could technically fall within this definition. Noting that clause 14 of the same bill inserted a new section 91A, which empowers the authority to impose an administrative penalty of up to 10%. A natural person who is unintentionally caught by the expanded definition could therefore face a significant penalty. And our proposed amendment being that adding a proviso to the definition of undertaking to include that, provided that a natural person shall not constitute an undertaking for purposes of this act, where that person carries on trade, business, or professional activity in the market, and shall not include a natural person acting as an employee or in their purely private capacity. We also propose amending clause 2 in the definition of digital activity. Currently, digital activity is a new addition to the Act, and it is defined as the provision of services through the internet or digital content, and includes online intermediation services, online search engines, social networking services, video sharing platforms, interpersonal communication services, operating systems, cloud computing systems, and online services. We propose that the definition of digital activity be accompanied by a material qualifier to limit its application to undertakings whose digital activity is principal or material aspect of the actual business. As it currently stands, the definition is very broad, as it includes cloud computing and online advertisement as services used by most ordinary businesses as part of their day-to-day operations, and not because they are digital market participants in the regulatory sense. without a material qualifier, a manufacturer that uses cloud storage or a retailer that runs social media adverts could technically fall within this definition. The provision should be limited to undertakings for whom the provision of digital platform services constitutes a principal or core business activity, rather than undertakings that merely utilize digital tools such as cloud computing, online advertisements, or social media as ancillary to their primary commercial operations. This would ensure that the definition captures genuine digital market participants without inadvertently subjecting ordinary businesses to digital market regulation solely by reason of their use of a widely available digital service. Still on the definition section, we note that the competition bill introduces two new concepts, and these are the strategic market position and superior bargaining position. So on the strategic market position, the bill provides that a person may have a strategic market position if it can significantly influence prices, quality, output, services, or innovation. With respect to superior bargaining position, the bill provides that a person will be deemed to have a superior bargaining position where there is an imbalance in commercial rights and obligations and the counterparty lacks a viable alternative. So our proposal is that the bill should clearly distinguish between these two concepts because they are overlapping with the existing concepts of dominance and market power. So under the current Competition Act, a firm is considered to be dominant if it has substantial control over a market, and this is typically through a high market share or the ability to act independently of competitors, customers, or suppliers. The Competition Act also already recognizes market power, which is the ability to control prices and also to exclude competitors or to behave independently of competitive pressures. So I'll give an example. For example, hypothetically, if a telecommunication company, let's say, has a 70% market share, and that company can increase prices without losing many customers because the customers have few alternatives, then that company will be deemed to have a dominant power and a market power. So the bill says that a person has a strategic market position if it can influence prices, quality, services, output, or innovation independently of competitors, suppliers, or consumers. So the problem with this is that it sounds very similar to the existing definition of market power. In addition, for superior bargaining position, this should be tied to some meaningful level of market influence rather than simply a bargaining imbalance between the parties. So our proposal is that given that these two new concepts overlap with the existing competition law principles, and they will create uncertainty for businesses given that they may struggle to understand when each of these two concepts will apply, an ordinary commercial relationship could potentially become subject to competition law scrutiny. Then these two should be distinguished. Our second, the next issue is on the repeal of existing abuse of buyer power provisions. So the bill proposes to repeal Section 24A of the Competition Act on abuse of buyer power and reintroduce a substantially similar provision under the new Part 3A, which deals with unfair market conduct. So what we are proposing is that the repeal should include a saving provision to preserve all existing investigations, complaints, proceedings, and orders that are made under the current Section 24A. The reason for this is because without the transitional provisions, ongoing cases and existing orders could become vulnerable to legal challenge once the repeal takes effect. On to the next one. The bill also introduces what I've talked about before on abuse of superior bargaining position, and it gives some example of what constitutes the abuse of superior bargaining position to include unilateral changes to contracts, transfer of risks and costs and collection of data, and difficult termination provisions, and contravention of this provision will attract criminal penalties. So what we are proposing is that this section 40B should be reconsidered entirely, because if it is retained, it should only apply where an undertaking has a significant market position, and the prohibited conduct should be assessed using an effects-based analysis rather than being treated as automatically unlawful. The reason why we are making this proposal is because the provision expands competition law beyond its traditional focus on market power and anti-competitive effects. So as drafted, many ordinary commercial agreements could potentially be challenged simply because one party has a greater bargaining leverage than the other. There's also an overlap between the abuse of buyer power and abuse of superior bargaining position. The bill proposes to include many forms of conduct, such as delaying payments, contract termination, and transfer of costs. These appear both in the abuse of buyer power provisions and the superior bargaining position. So what you are proposing is that these two regimes should be clearly separated. The abuse of buyer power should be supplier relationships, and superior bargaining position should apply to broader commercial relationship. This is because the current drafting creates uncertainty and could expose businesses to multiple claims arising from the same conduct, given the similarity of what constitutes abuse of buyer power and abuse of superior bargaining position. So on to the next, the bill also proposes to treat the unreasonable collection or processing of a counterparty's personal data as an abuse of superior bargaining position. So what we are proposing is that there should either be a carve-out for matters that are already regulated under the Data Protection Act, or there is a formal coordination mechanism between the Competition Authority of Kenya and the Office of the Data Protection Commissioner. The reason for this is because data protection issues are already regulated under the Data Protection Act, and the current proposal will risk duplicating investigations and potentially conflicting decisions by different regulators. The bill also proposes to prohibit obstruction of business activities and interference in the management of a counterparty's business. What we are proposing is that this provision should be narrowed, and it should expressly exclude common contractual protection, such as board observer rights, approval rights, reporting obligations, veto rights, and lender protections. The reason for this is because the wording is very broad and it captures many legitimate contractual arrangements which are commonly found in joint ventures, financing transactions, and commercial contracts.
I will highlight our proposed I will highlight our proposed amendment to clause 10 and section 41(2)(1) that seeks to categorize privatization as a merger. And our thinking on this is that the extension of merger control to privatizations, it genuinely serves a legitimate purpose of ensuring that the transfer of state-owned assets to private ownership is reviewed for its effects on competition. That said, there appears to be three practical problems. Firstly, we have two authorities. So first, the Competition Authority of Kenya under the Competition Act and the Privatization Authority under the Privatization Act of 2025, both seemingly having overlapping roles in relation to the same transaction. So without an express coordination mechanism between those two regulators, there's a real risk of inconsistent decisions or delays. Then secondly, the standard merger review process can be quite lengthy, and government privatization transactions are subject to investor timelines and fiscal obligations that standard review period. So in our view, would be necessary to ensure that merger control does not become an obstacle. Number one, a coordination mechanism requiring the authority, in this case the CAK, to conduct its review in consultation with the privatization authority established under the Privatization Act, and limiting the authority's review only to the competitive effects of privatization rather than the merits of the underlying government policy decision, which is catered by the privatization authority. And then secondly, an expedited review timeline for privatization transactions, which the CS may prescribe by notice and which will not exceed 30 days.
Moving on, the bill proposes to introduce a new offense of withholding material information about the quality and use of goods and services. So what we are proposing is that material information should be defined, and a person should only be penalized where the person knowingly withholds such information. So without the limitation, a business could face liability for innocent mistakes or unintentional omissions. The bill also proposes to give the CAK broad powers to impose administrative sanctions, including penalties of up to 10% of a business annual turnover, suspend rights and privileges, and recover penalties as civil debts. So what we are proposing is that the bill should provide a minimum notice period before enforcement proceedings can be taken by the CAK. And it should also prevent enforcement of penalties until the appeal rights have been exhausted or the penalty has been confirmed by the competition tribunal or by a court. We also noted that there are absence of transitional provisions. So all these new rules that are being proposed by the bill will apply immediately upon commencement of the legislation. So we are proposing a 12-month transition period to allow businesses to review and amend their existing commercial agreements and arrangements. During this time, the CAK should also issue guidance on compliance with the new provisions. That makes the end of our submissions on the competition bill.
Thank you very much for your submissions. Okay, now it is. Thank you very much for your submissions. Are there concerns from members? Okay, I think your submission is very clear. I particularly note the concern about the overlap between the roles in the Privatization Act and now the competition bill, and of course the threshold of the responsibilities being done by the competition authority on the transactions and your other contributions. Thank you very much. Please do pass our regards to our partners and tell them we've missed their presentations. But it's good they are mentoring the younger generation, because thank
you very much.
They will be there forever. Sintani, Bowmans.
we agreed.
You should have requested for the term.
Yeah. Hii maneno ya makaratasi. Mpito wa makaratasi. Okay, you are here when you're doing the round of introductions, so just take us through your submissions, and they're quite something. So you try to use your time well. Introduce yourself and take us through your submissions.
Sure. Thank you, Chair. Afternoon, Chair and honorable members. Thank you for inviting us to your chambers today. My name is Mutugi Motegi, a senior associate at Bowman School Sonani LLP in the competition practice. I'll let my colleague introduce herself.
Good afternoon to the Honorable Chair and the Honorable Committee. My name is Michelle Kimonye, a Senior Associate at Bowman's in the competition practice.
So just to go over, as Chair, you have noted our submissions are quite detailed, but also cognizant of the busy schedule that you have and the other stakeholders will wish to submit, we'll kind of summarize on the key elements that we want to focus on. But while in making our submission, before we get into substantive elements, I think the core thing that we wanted to point out here is that while we support this amendment, there are certain fundamental issues that we think need to be resolved. In that, first of all, we need to define what problem is being solved by these amendments so that we can make the solution more precise. Because the challenge that we're having and the reason why our submissions are that detailed is that we believe the problem may exist, but it has not been defined correctly or accurately. And as a result, we may find ourselves in a position where the solution being suggested by the competition authority or by the drafters may end up being larger than the problem that it seeks to solve. So the first thing we are proposing to the definitions, as you'll see at page 2 of our submission, there are a number of definitions under the interpretation section we believe should be deleted for some other reason. Some of the reasons for the deletion will be evident in the explanations we'll give, because they are as a result of other amendments that we propose. But I think two that we would like to focus on are with respect to the definition of business consumer. First, on the definition of business consumer. So under section, it's the amendment bill is proposing to amend the definition of business consumer, which is relevant for the provisions with respect to consumer protection under the Act. What you'll notice is that there's already a proposal to amend the definition of a person to align it to the definition of a person under Section Article 2260 of the Constitution. We think that the definition currently proposed under the bill kind of deviates from that, and it should be more aligned towards aligning with the definition of a person under the Constitution. And for that reason, our proposal is that the definition of business consumer should read that it means a person other than a natural person acting in a personal capacity that purchases or offers to purchase goods or services for use in the course of carrying on a business, but not for the purpose of resale or for the purpose of using those goods or services as an input for the manufacturing or production of goods or articles.
Around the definition of family in Article 27 of the Constitution?
Beg your pardon. We are referring to
in relation to Article what?
Article 260 of the Constitution.
260.
Yes. Yeah. So there's already an amendment being proposed under the amendment bill to align the definition of person with that. I think given that the word person is being used consistently across the Act, the definition should as well align with that, just to make sure that there's no ambiguity in interpretation going forward. for alignment with other statutory provisions is the definition of digital. New definition, essentially, given that this amendment bill is primarily focused on competition authorities regulation, we think it's critical to get this definition from the start. And for that reason, I think we can get some guidance from what the definition under the taxation laws in Kenya read as, where our suggestion is to align with what the KRA as well sees as a definition of a digital. It does not use the word digital activity, it uses it to refer to it as a digital service, and that definition is as a digital service is a service offered through a digital platform that enables direct interaction between buyers and sellers of goods and services. Essentially, this will ensure that, and then of course this will also necessitate a wholesome definition of the term of digital activity across the amendment bill as well. If I may go on now to more substantive definitions or other subjects that we're dealing with, or rather, as my colleague will actually deal with, apologies. Michelle will touch on the concept of abuse of buyer power as well as abuse of superior bargaining position.
Okay, thank you, Mutugi. So I will begin by covering the new regime that is being proposed, the abuse of superior bargaining position. I think our first overall general comments on this introduction is that there appears to be some overlaps between this new, what I'm calling regulatory provision oversight and what is already in the Competition Act. The Competition Act has the abuse of buyer power already, and that seems to fit neatly within the abuse of a superior bargaining position. So I think our first generic comment is that if the drafters want to keep the abuse of superior bargaining position provisions, then we should get rid of the abuse of buyer power provisions entirely, because there's a lot of overlap between those two. So in terms of the definition of the abuse of a superior bargaining position under Section 4.6 of the bill, it defines, the proposed Section 4.6 defines a person as having a superior bargaining position in a market if that person creates an imbalance in the rights and obligations relating to its commercial relations with a counterparty, and the counterparty cannot find a viable and satisfactory alternative in the market. So we think that this definition presents several deficiencies. First, it's a bit vague, as it doesn't go into the details of what it means to have an imbalance in rights and obligations. Most, if not all, commercial agreements have an imbalance in them, and so we think this is stretching the regulatory oversight of the authority a bit too far, because natural commercial agreements will have an imbalance. We think this definition should be connected to specific harm, is our proposal. So we are respectfully recommending that the authority revise the definition of superior bargaining position in the proposed Section 4.6 to incorporate objective and measurable criteria. In particular, the definition should require an assessment of factors such as the degree of the counterparty's economic dependence on the undertaking in question, including establishing the proportion of revenue that is derived from that commercial relationship, the availability of genuinely comparable alternative trading partners, and the switching costs that would be incurred in transitioning from one trading partner to another. Going into the specifics of the abuse of superior bargaining power provisions, if you turn to page 16 of our submissions, Section 41B, so what we have noticed is that the proposed Section 40B1, which provides that a person shall not engage in any conduct that amounts to abuse of superior bargaining position in any market in Kenya or a substantial part of Kenya, the key absence here is that it doesn't require competitive harm. And the purpose of the Competition Act is to regulate competition in Kenya. And so we think it's important that these provisions are linked to the harm that the Act is trying to mitigate. So in this regard, we are respectfully recommending that the proposed Section 40B1 be amended to introduce a competitive harm requirement, we suggest that the provision should read, a person shall not engage in any conduct that amounts to abuse of a superior bargaining position that causes or is likely to cause harm to competition in a market in Kenya or a substantial part of Kenya. Still sticking to the abuse of superior bargaining power provisions, I will now cover section 40B2. The proposed section 40B2 sets out an expansive and non-exhaustive list of conduct that may constitute abuse of a superior bargaining position. Several items on this list are broadly framed as to capture ordinary legitimate commercial behavior, and several others are undefined or lack meaningful limiting criteria. Our recommendations are therefore that these provisions need to be limited and be made a little more specific to avoid the risk of chilling legitimate commercial negotiations between parties. So each item of prohibited conduct in section 40B2 needs to be reviewed and where necessary qualified to ensure that it captures only genuinely abusive conduct and does not inadvertently prohibit legitimate commercial behavior. We've made several proposals in this regard. So section 40B2A, the current drafting prohibits delays in the payment of suppliers without justifiable reason in breach of agreed terms of payment. And our proposal is that it should be amended to say systematic or persistent delays in the payment of suppliers without objectively justifiable reason in breach of agreed terms of payment, where such delays are not attributable to a genuine commercial dispute between the parties regarding the conformity, quality, or completeness of the goods or services supplied. So our amendment is tailored to just sort of make it a bit more specific, the circumstances in which a delay in a payment to a supplier may result in an abuse of that relationship, because delays happen for various reasons, as we know. Moving on to section 40B2B, the provision as currently drafted prohibits unilateral termination or threats of termination of a commercial relationship without notice or on an unreasonably short notice and without a justifiable reason. Our proposed amendment would say unilateral termination or threats of termination of an established commercial relationship without notice or on an unreasonably short notice, having regard to the duration and nature of the relationship, the investments made by the supplier or counterparty in reliance on the continuation of the relationship, and any applicable industry norms, and without an objectively justifiable reason. Section 40B2C, which still falls under the abuse of superior bargaining position, this provision prohibits failure to provide the counterparty with terms, conditions, or other rules associated with the transaction or service prior to the transaction or provision of the service. So this provision, we think, imposes an absolute, unqualified disclosure obligation with respect to all terms, conditions, and rules associated with a transaction, regardless of their materiality, the nature of the industry, or the stage of the commercial interaction. It doesn't account for the reality that in many industries, terms are negotiated iteratively and are customarily finalized at the point of contract execution. So our proposal for this provision is that it should instead say, failing to provide the counterparty with material terms, conditions, or other rules associated with the transaction or service within a reasonable time prior to the conclusion of the agreement or the commencement of the provision of the service, where such failure prejudices the ability of the counterparty to make an informed commercial decision. So it's just to qualify it and make it a bit more specific. Moving on to section 40B2D, and this provision covers the unilateral variation of contractual terms, and it prohibits the unilateral variation of contractual terms, conditions, or other rules associated with a transaction or service without prior notice to the counterparties. So we are of the view that this is already a matter of general contract law. Unilateral variations without contractual authority are typically unenforceable as a matter of common law. The inclusion of this provision in a competition statute enforceable by criminal sanctions is disproportionate and risks regulatory overreach. Moreover, the provision makes no distinction between material and immaterial variations. And for this provision, we are recommending that it's deleted in its entirety. Section 4B2E on transfer of costs. This provision prohibits the transfer of costs to a counterparty. If taken at face value, this would prohibit any contractual allocation of costs to a counterparty, which is a fundamental feature of virtually all commercial transactions. And so for this provision, we are proposing that it reads instead, the unilateral transfer of costs to a counterparty that were not contemplated by the parties at the time of entering into the agreement and that are not the produce of genuine commercial negotiation between the parties, including but not limited to the unilateral imposition of a requirement for the counterparty to fund the cost of promotion of goods or services. Moving on to section 40B2F, this is page 18 of our submissions. This provision prohibits the transfer of commercial risks meant to be borne by a party to the counterparty. So the provision assumes a clear and ascertainable allocation of commercial risk, but doesn't provide a criteria for identifying what that allocation should be. The allocation of risk is precisely what parties negotiate, and the outcome will vary depending on relative bargaining strength, the commercial context, and the industry norms in which that contract sits. So the provision we are proposing would rather read, unilateral transfer of commercial risks that, by the express or implied terms of the agreement between the parties, or by established practice in the relevant sector, were meant to be borne by that party rather than the counterparty. Then we move on to section 40B2G. The provision prohibits demands for preferential terms unfavorable to the counterparty, and we are proposing that it reads, demands for preferential terms that are substantially unfavorable to the counterparty and that are not objectively justified by reference to the volume or other legitimate commercial characteristics of the transaction, or demanding limitations on supplies or services to other commercial context of the relationship, and substantially restrictive the counterparty's ability to compete in the relevant market. We're just trying to sort of where the demand for a preferential term by a supplier would constitute abuse, because we know in most commercial relationships between suppliers and their customers, there will be preferential terms based on what the supply is relating to and the volumes being supplied. Moving on to section 40B2H, this provision prohibits imposing purchase prices below competitive levels or service fees above competitive levels. So we are of the view that this provision is problematic because it presupposes the existence of an identifiable level for prices and fees, which is extremely difficult to determine and is a subject of extensive debate in competition economics. We are proposing that rather, section 40B2H should read, imposing purchase prices significantly below the prevailing market price for comparable goods or services in the relevant market, or significantly above the prevailing market rate for comparable services in the relevant market, where the counterparty has no viable alternative and the pricing is not objectively justified by the commercial characteristics of the transaction, including the volume, quality, or timing of the supply. Again, these provisions are being proposed to allow parties the freedom to enter into their commercial relationships as they see fit, but still dealing with the issue of possible abuse in those relationships. Moving on to section 40B2I, which deals with unreasonable collection or processing of data. The provision prohibits the unreasonable collection or processing of data of the counterparty. We had previously submitted that there should not be a presumption that the mere collection and use of data by an undertaking will necessarily harm competition. Data-driven business models frequently promote consumer welfare, and concerns about data privacy are also addressed through Kenya's Data Protection Act. Absent a showing of harm to free and fair competition, the inclusion of data-related conduct in a competition statute risks creating regulatory duplication between the Competition Act and the Data Protection Act, and uncertainty as well. Our proposals in this regard is that the Section 42BI should read, collection or processing of data of the counterparty in contravention of applicable data protection legislation, or where no such legislation directly applies to the processing of data that is not reasonably necessary for the performance of the transaction or the provision of the service, and that causes or is likely to cause competitive harm. And as I said, this just recognizes that the Competition Act should be and allow the other legislations that we have to deal with their primary concerns, like the Data Protection Act. Moving on, still under Section 40B, which is the abuse of superior bargaining position, subsection 2J, the provision prohibits imposing unduly difficult conditions for the termination of services. The term unduly difficult is subjective and undefined. The provision also offers no benchmark against which the difficulty of termination conditions is to be assessed, and no basis for distinguishing between conditions that are exploitative and those that are commercially justified. Our proposal in this regard is that it should rather, the prohibition should read, imposing conditions for the termination of services that are substantially more onerous than those that would be expected in comparable commercial relationships in the relevant sector, and that are not objectively justified by the nature of the service, by relationship-specific investments made by the party imposing such conditions, or by the terms expressly agreed between the parties. Moving on to Section 40B, subsection 2K, this provision prohibits the obstruction of business activities or interference in the management of the business of a counterparty. We are of the view that it's an extraordinarily broad prohibition that could capture a wide range of ordinary and legitimate commercial conduct. This provision, as currently drafted, does not distinguish between deliberate and coercive interference on the one hand and the legitimate exercise of contractual rights on the other hand. And it is with this in mind that we're proposing the following amendment, that it should rather read, the deliberate obstruction of the core business activities of a counterparty or unwanted interference in the management of the business of a counterparty other than conduct that is, 1, expressly authorized by the terms of the agreement between the parties, and 2, reasonably necessary for the protection of the legitimate commercial interests of the party concerned, including the protection of intellectual property, brand standards, or product quality, or 3, required by applicable law or regulation. In addition to those amendments we're also proposing the insertion of 2 new sections under Section 40B. So it would be Section 40B 2L, following K, and it should say that it should prohibit the refusal to receive or return any goods or a material part thereof without objectively justifiable reason in breach of agreed contractual terms, other than a refusal that is attributable to the non-conformity of the goods with the contractual specification or to the counterparty's failure to comply with agreed delivery terms. And this just deals with those situations where there's been a refusal to return goods without any reason between suppliers and their customers. And then a new Section 40B2M should say bidding up prices of inputs to a level significantly above the prevailing market price for such inputs, where such conduct has the purpose or likely effect or substantially restricting the ability of competing undertakings to access those inputs in the relevant market, and where such conduct is not objectively justified by the parties' genuine commercial requirements for those inputs. So basically our comments are that the list of prohibited conduct should be made exhaustive rather than illustrative, at least until the authority has developed sufficient enforcement experience and case law to provide guidance on the scope of unlisted conduct. Alternatively, a catch-all provision should require a demonstration of competitive harm, and the authority should be required to demonstrate, on the basis of economic evidence, that the conduct in question has caused or is likely to cause substantial harm to competition in the relevant market, or substantial and unjustifiable harm to or economic disadvantage to the affected supplier. Moving on to section 40B6, this is on the criminal sanctions that have been proposed under the abuse of superior bargaining position. The proposed section 40B6 provides that a person who contravenes the abuse of superior bargaining position prohibition shall be liable on conviction to imprisonment of a term not exceeding 5 years, or a fine not exceeding 10 million shillings, or to both. We consider the application of criminal sanctions, including imprisonment, to what is fundamentally a contractual or commercial dispute to be disproportionate and inappropriate. As we had submitted, the application of criminal sanctions to contractual arrangements is unnecessarily severe, and administrative penalties would be more appropriate. So we respectfully recommend that the criminal sanctions in proposed section 40B6 be deleted and replaced with administrative penalties in line with the enforcement mechanism introduced in proposed section 91A. In the alternative, if the authority considers that criminal sanctions should be retained for the most egregious forms of abuse of superior bargaining position, the provision should be narrowed so that criminal liability attaches only to deliberate, repeated, or systematic contraventions that cause demonstrable harm to competition or to a counterparty, and only after the authority has first issued an administrative order which has been contravened. I think our submissions on the abuse of superior bargaining power are resting there. I will move on to abuse of buyer power as I conclude. I think my initial comments were that there is an overlap between these two sections of the bill, and we think that abuse of superior bargaining power firmly deals with any matters that may arise from the abuse of buyer power itself, and there is no need for these two provisions. But looking at the abuse of buyer power provisions specifically, section 40A. So our first recommendation in this regard is that section 40A be deleted from the bill because it has been covered under abuse of superior bargaining position. So there has been a removal of mandatory minimum agreement terms. Section 24A7 of the current Act, the Principal Act, imposes a mandatory requirement that every agreement between a buyer and a supplier shall include specified minimum terms, namely the terms of payment, the payment date, the interest rate payable on late payment, the conditions for termination and variation of the contract, the mechanism for the resolution of disputes. This is a significant structural protection. By requiring that buyer-supplier agreements include these minimum terms, Section 24A7 of the Principal Act operates as a preventative mechanism. It reduces the scope for abuse by ensuring that the foundational terms of the relationship are documented, transparent, and agreed in advance. It also provides a clear contractual baseline against which the authority can assess whether subsequent conduct amounts to abuse. These minimum agreement terms have been removed from the current bill, and we respectfully recommend that the mandatory minimum agreement terms currently set out in Section 24A7 of the Principal Act be carried over into proposed Section 40A if it is to remain within the bill. We've also made significant proposals on the amendments to Section 40A1. This is now specifically on abuse of buyer power. The proposed Section 40A1 provides that a person shall not engage in any conduct that amounts to abuse of buyer power in a market in Kenya or a substantial part of Kenya. This is framed as an absolute prohibition with no requirement that the impugned conduct cause or be likely to cause harm to competition or the competitive process. In this regard, we respectfully recommend that the proposed Section 40A1 be amended to incorporate a competitive harm requirement, such that the prohibition reads, "A person shall not engage in any conduct that amounts to the abuse of buyer power and that causes or is likely to cause harm to competition in a market in Kenya or a substantial market in Kenya." Page 25 of our submissions, we will deal with Section 40A2, which is abuse of buyer power and the conduct prohibited under that section. The proposed Section 40A2 sets out an expansive and non-exhaustive list of conduct that may constitute abuse of buyer power. Several items on this list are broadly framed as to capture ordinary legitimate commercial behavior, and similar to the provisions on abuse of superior bargaining position, several others are undefined or lack a meaningful limiting criteria. So Section 40A2A, the current provision provides for delays in payment of suppliers without justifiable reason in breach of agreed terms of payment. This provision, we feel, fails to distinguish between isolated or inadvertent payment delays and systematic, deliberate late payment used as a tool of economic exploitation. We respectfully recommend that it be amended, if Section 40A is going to be kept, to read systematic or persistent delays in the payment of suppliers without objectively justifiable reason in breach of agreed terms of payment where the delay is not attributable to a genuine commercial dispute between the parties regarding the goods or services supplied. Section 40A2B, currently as it reads, it states that it prohibits the unilateral termination or threats of termination of a commercial relationship without notice or an unreasonably short notice and without an objectively justifiable reason. Our proposed amendment is that it should instead read, "The unilateral termination or threats of termination of an established commercial relationship without notice or an unreasonably short notice, having regard to the duration and nature of the relationship, the investments made by the supplier in reliance on the continuation of the relationship and any applicable industry norms, and without an objectively justifiable reason." So you'll notice that our proposed amendments are very similar to those of abuse of superior bargaining position, because the provisions read very similarly, and which is why we are saying there's some overlap with these two sections of the bill. Section 40A2D, the provision prohibits the transfer of costs or risks to suppliers of goods or services by imposing a requirement for the suppliers to fund the cost of promotion of the goods or services. Again, we think that this should be qualified appropriately and should rather read unilateral imposition on suppliers of goods or services of a requirement to fund the cost of promotion of the goods or services where such requirement was not contemplated by the parties at the time of entering into the supply agreement and is not the product of genuine commercial negotiation between the parties. Section 40A2E, this provision prohibits the transfer of commercial risks meant to be borne by the buyer to the suppliers and assumes a clear and predetermined allocation of commercial risk between buyer and supplier, but provides no criteria for identifying what that allocation should be. Our proposal is that the prohibition should instead read, unilateral transfer of commercial risks that, by the express or implied terms of the supply agreement or by established practice in the relevant sector, were meant to be borne by the buyer rather than the supplier. Section 40A2F, the provision prohibits demands for preferential terms unfavorable to the suppliers or demanding limitations on supplies to other buyers. The provision conflates two conceptually distinct types of conduct, namely the demand for preferential terms and demands for exclusivity, without providing any framework for assessing either of them. Demands for preferential terms are a routine feature of commercial negotiations, as we said, and are in many cases pro-competitive, driving down input costs which may be passed on to consumers. Our proposal is that it should instead read, demands for preferential terms that are substantially unfavorable to the suppliers and that are not objectively justified by reference to the volume, value, timing, or other legitimate commercial characteristics of the transaction, or demanding limitations on supplies to other buyers where such limitations are not objectively justified by the commercial context of the relationship and have the effect of substantially restricting the supplier's ability to compete in the relevant market. Section 40A2G, this prohibition prohibits reducing prices by a small but significant amount where there is difficulty in substitutability of alternative buyers or reducing prices below competitive levels. The provision as it is does not specify the quantum, the duration, or the methodology by which a small but significant reduction is to be assessed. The concept of difficulty in substitutability of alternative buyers is also vague. It's unclear what degree of difficulty is required, how substitutability is to be assessed, or whether the assessment is to be made from the perspective of the supplier, the market, or the authority. So in terms of this provision, we think that, the amendment bill, provides no guidance on the methodology the authority should apply, what evidence is required, or how the competitive level is to be ascertained. The provision captures all pricing below competitive levels without any materiality threshold. And so our recommendation is that it should instead say imposing purchase prices significantly below the prevailing market price for comparable goods or services in the relevant market where the supplier has no viable alternative buyer and the pricing is not objectively justified by the commercial characteristics of the transaction, including the volume, quality, or timing of the supply. Moving on, I think I will cover page 29 of our submissions, which again deals with the criminal sanctions. Section 40A7 proposes to include or to bring in criminal sanctions for the abuse of buyer power. And it provides that a person who contravenes the buyer power prohibition commits an offense and shall be liable on conviction to imprisonment for a term not exceeding 5 years or to a fine not exceeding 10 million shillings or to both. This reproduces the existing sanction in Section 24A9 of the Principal Act. As we had previously submitted, we are of the view that administrative penalties would be more appropriate for contractual matters, and that the criminal sanctions in proposed Section 40A7 should be deleted and replaced with administrative penalties, in line with the enforcement mechanism introduced in Section 91A. And I think I will stop there. I have covered the two items that we meant to go into details on and hand over to Mutugi.
So if I may close out on now the strategic market position provisions under the Act. Just give a, yeah, I noticed the distraction. So just going to cover the strategic market position provisions, which are covered under page 6, or rather page 5 to 13 of our submissions. I'll just try to summarize them, but essentially it goes back to what our introductory remarks were, that because of the concepts which are being introduced, they've been introduced without reconciling with existing provisions which already exist in the Act. And here is one other example, similar to what my colleague Michelle has pointed out, that there is already a concept of abuse of buyer power, and now we're introducing abuse of superior bargaining position, and the two are essentially the same thing. In this case now, we are introducing strategic market position, which is already catered for by the provisions called market power, the provision on market power under the Act, because the two things, strategic market position and market power, essentially turn on the same thing, which is the ability to act independently of competitive constraints to an appreciable effect or extent. So essentially what we're trying to suggest here is on either one hand, similar to our previous suggestions, either we delete these proposed amendments and just retain the provisions on market power, but if not, then we try and make sure that the two provisions can coexist, or at least some reconciliation is done. In this case, essentially what we're trying to say is strategic market position, from how you read the Act, by the provision it tries to introduce under under clause 3, 4, and 3.5 of the amendment bill, essentially seems to be targeting digital platforms or digital services as per the definition that we had described. Because this is not an area which is covered under the law, or rather ideally captured under regulation at the moment. If we are going to introduce these provisions, then we should at least try and ensure that it targets, as you will see on page 7 of our submissions, it identifies a direct regulatory purpose that it is trying to target. These strategic market power provisions, we can tell from our experience advising on other markets, that they are based on a similar piece of legislation out of the United Kingdom called the Digital Markets Competition and Consumer Act 2024, which took quite a bit of time to be developed, and I think is quite instructive about the ideal way to target the concept of strategic market position. Essentially, what if we are able to figure out what exactly we are targeting here, then we can get the proper provisions to target. If it is indeed digital markets which we're trying to bring into the scope of the competition authority of Kenya, then I think the various provisions which are under the DMCC of the UK are good examples that we can use, not essentially to copy, but at least theoretically to see an ideal way of targeting. And so I'll go into the specific amendments that we have tried to propose in that respect. The main thing is that the current provisions under the amendment bill do not propose a concept of entrenchment. And by entrenchment, what we mean is that we do not want these provisions to just target a transient element of power. It must be somebody who has established that power and is sustaining it over time. And which is why in comparative jurisdictions, they look at, they do a forward-looking assessment over up to 5 years to ensure that that power which has been attained is entrenched and not just something which is transitory over, say, 1 or 2 years or just a couple of months. The second element that we are proposing should be added in is the concept of strategic significance. In that entity must essentially show that it has that is being targeted as having strategic market power. Going from the name itself, should be shown to have strategic significance. So it's not just having the market power alone. If you have that market power, but it actually has no substantial significance, or there are other players in the industry who are able to counter your power, then really I don't think that is the target of who we're trying to regulate. So essentially, that is why we have made proposals under subsection 4A of the clause 4A, where we propose that the amendment should read as, in order to assess whether an undertaking, sorry, I'll actually start with the wrong one. Essentially, let us begin first of all with how we define strategic market power. Essentially by amending our proposal to amend subsection 3 or section 3.4, where we say an undertaking involved in a digital activity has a strategic market position in a digital market in respect of that digital activity, where the authority considers that the undertaking has a substantial and entrenched market power in respect of the digital activity, and that is where we state substantial and entrenched market power, and then the undertaking holds a position of strategic significance. In the subsequent provisions, we have proposed amendments now then to introduce these two concepts of substantial and entrenched market power, and B, the position of strategic significance. And it reads subsection 4A, we have proposed that it should read as follows. In order to assess whether an undertaking has substantial and entrenched market power in respect of a digital activity for the purposes of subsection 4A, the authority shall carry out a forward-looking assessment for a period of at least 5 years, taking into account A, the direct and indirect effects of network effects and the barriers to entry arising in connection with those effects. B, the economies of scale and scope enjoyed by the undertaking, including access to the data relevant for competition. C, the cost of switching for users and the ability and propensity for users to multi-home, which is also a definition which has already been introduced has been proposed within this amendment bill at section 2. The competitive pressure driven by innovation. developments that will be expected or foreseeable if the authority did not designate the undertaking as having that SMP. As you can see, what we're trying to target here, or proposing should be targeted here, is that if we are targeting digital markets, everybody here has seen how innovative these markets are. A few years ago, you did not have your ChatGPT, you did not have your Claude, you did not have these other things. If, for example, right now we try to impose these kind of provisions on an entity like that, how do we know that in the next couple of years that entity will exist and actually have that amount of influence in how we actually interact with these digital markets? So that is why we're proposing this should be a more forward-looking and targeted towards more entrenched market power rather than something which is more transient. The other provision that we have suggested is now going into the concept of is that strategic significance should be identified. Undertaking has achieved and here we are using the word digital service. B, a significant number of other undertakings. The undertaking's position in respect of the digital activity would allow it to extend its market power to a range of other activities. D, the undertaking's position in the allows it to determine or substantially influence undertakings and conduct themselves in respect of the digital activity or other. Proposed here is a draft be targeting digital activities or digital services, if you may allow, that are entrenched and have their hand, are able to reach into the different mechanisms or different ecosystems that exist. Because in competition law, what we call it is, and the concept of what has become the common study is that you're not able to define what a market is in the concept of digital markets, but instead you want to look at an ecosystem. So here, what our description is making clear is essentially, without using the word ecosystem, that is what that wording essentially describes. Essentially, now to go into additional provision that we have proposed, borrowing from the UK's comparative guidance or comparative legislation that we find kind of instructive in this circumstance. One, in the UK and other jurisdictions, they have a process that they follow for these kind of entities who have grown to this level of significance, a formal designation process, where you give an opportunity for that entity to, first of all, the authority to have a look at the level of what is the characteristics of this ecosystem, how entrenched is this entity and the services that it provides, and then consider, first of all, and give that entity the right of reply and the chance for it to defend itself. So you'll find we have proposed new subsections. I will not go through them verbatim, but you can go through at page 8 of our submissions, where we indicate formal designation process for subsections 4, 4C to H, where the CAK will have that opportunity to identify, investigate, allow that opportunity a chance or right of reply, which is in line with our constitutional provisions and the right of fair administrative action, and then following that, make a decision whether indeed that entity should be designated as having a significant strategic market position. Following then, and here we take learning from what the CAK has very effectively already done in the retail sector in Kenya. A couple of years ago, as you may all remember, we had the various collapses of the retail entities. And after a significant intervention by not only the national government, but this August House itself, there was a retail code of conduct that was imposed on various retailers. And so far, there has been a significant improvement or less complaints about the concept of buyer power by these various itself 2 years ago did a study on these markets and said that the ideal route for it to take is for these entities to self-regulate. This was the market inquiry into online food retailers and delivery systems. In this study, it said that these markets are competitive. The ideal route is not for us to intervene, but leave it to these entities to self-regulate because these markets are still competitive. Our view, at least from our assessment and advising clients, and also, well, our experience as customers themselves of these digital systems, is that these markets are still competitive. So we should at least leave these spaces to be determined or at least controlled on a code of self-regulation, which the CAK has supervisory authority over consistently, and if you breach it repeatedly or extremely, the CAK can then step in. So that is what we've proposed from subsections 4 to 4I to L, which, so essentially the sequence shall be that the CAK will investigate, designate you, give you a right to respond to that designation, and thereafter then impose with consultation with, of course, that industry, a code of self-conduct which can act as a self-regulatory mechanism within that system, and of course with levels of public participation that will allow the customers and other affected stakeholders to be involved. So essentially that, and with that as well, because it's the one thing that we noticed, this provision doesn't have substantive penalty mechanisms imposed. Contrary to public opinion, law firms are not always just looking to make sure that our clients don't get penalized. We do try and find a middle ground here. It may sound counterintuitive, but we have also proposed that there should be a level of enforcement of penalties in this particular circumstance. So that is why under subsection 4, N, M, and N, there are various proposals which are made, which are in line with the other basic penalties which we have been proposed within the Act, which we find are significantly punitive and in line with international best practice. As a result of these proposals that we are proposing, and if the House considers appropriate, you may consider adopting or proposing to the House to adopt, subsection 3.5 falls away, because subsection 3.5 essentially reproduces the concepts of market power. The same thing that we said at the beginning is in conflict, that it already exists under the Act. Now it has reproduced them, but not tying them correctly or accurately enough with the problem which we are trying to solve. So as a result, we propose that subsection 3.5 should be deleted and instead be replaced with the various provisions that we have suggested ahead. So that's our submission with respect to the SMP. I'll let Michelle close out on this.
Thank you, Mutuki. So in summary, I think just to summarize our concerns, the first one, of course, is a general concern regarding regulatory overreach by the authority, because we think certain things in the bill are adequately dealt with already in existing legislation. We think the authority's focus should be on competitive harm, and because that's its mandate, to regulate competition in Kenya. So with regards to the provisions that Mutugi has gone through, as they are drafted, we think there's a risk that they could be introducing over-regulation on digital players. And we acknowledge that the digital market is a growing market of significance to this economy. So we think that is something that the committee can prioritize looking at. We think there should be a streamlining of the existing provisions of the Principal Act and the overlaps between its provisions and the ones in the amendment bill to streamline those legislations. So for instance, what we said is that the Act already deals with abuse of buyer power. It is now introducing the concept of abuse of superior bargaining position, and pursuant to that, we think the abuse of buyer power provisions should be struck off the bill. And I think, yes, another comment we have is that most of these provisions need supporting regulations. And of course, once the Act is passed or considered by Parliament, we think a priority should now be for the authority to detailed regulations expounding on the new issues that in the Competition Act. And I think that closes out our submissions, and we'll happily take questions from there. Thank you.
Thank you very much. That has been a very, very detailed submissions. It's like you're rewriting the whole bill, considering all the far-reaching amendments that you proposed. But listening to you, I think it's coming very clear that this particular law is very, very important, and it will significantly change how businesses actually do business in Kenya. And I think you've brought out the issue of regulatory overreach very, very clearly. And then the issue of digital marketplace, the issue of abuse of power. And I think most of your concerns are really legitimate. So I think it's very important that as we consider your submissions, we balance, between giving CAK, the Commission Authority of Kenya, the regulatory powers, but also not crippling the way business people run the businesses, and especially the examples you've given on digital platform, on online trading and digital platforms, and how that self-regulation and what was done on the retail business, how that created sobriety in that space without necessarily becoming overreaching. And I think this is a bill that we have to be extremely careful when we'll be proposing amendments to it, because it will also significantly lead to a lot of court cases. Because if all these matters are not addressed, then you could find businesses always being in court rather than running the businesses because of being sued left, right, and center for things that could have easily been taken care of through conduct in the market, in the competitiveness. Thank you very much. Honorable Ruto, you have concern?
Thank you. I think, Chair, you've squarely put it, listening from the woman. I can say they have really brought out a reflection that it might cause us to keenly look at all clauses, especially with the concern or the risk of aspect of creating multiple powers over the same thing. But my concern is this is an entity, it is an agency that is mandated to look at the business environment to ensure that there is a fair play field for business to traverse. So you really picked up on critical issues, which I feel, I don't know whether you looked at the objective of this amendment in this bill, because the objective to me is trying to align the agency to the current status of the business environment, that the business of yesterday and the environment of business today are two different worlds apart. And that for us, as long as we still feel as a nation that we need this agency to manage the business environment, then we need to provide enough tools. We need to give teeth enough to fight. Teeth enough to bite, so that we are able to instill a character in, because this business is changing. We are in a digital world that the digital of yesterday and today are different. You mentioned AI, chit-chat, and all that, the clone which are working now. How do you think we should be able to support this agency? Because that's what I've looked at. Lastly, you're from a professional body. Likewise to me, prior to here, I was practicing. But I rarely get to hear on the changes in the market of professional services. I know there are professional services we don't compete, we don't market, we wait for clients to work in. But at times, how do clients choose the best firm or professional body or a business to undertake those consultancy services? Do you think, others touching on that, I want to speak on behalf of the professional bodies, because me as an accountant, the only thing I can do is to just say, alert that I'm here. The rest of it, let clients work, choose, they can hope until they find me. Do you think with this, we need to flex on something so that we're able to speak on the services we are giving and the kind of quality, promote the quality of work we are doing? Because earlier we were cut not to do it. Thank you.
Thank you, Honorable Member. So I think, first of all, thank you for the kind... yes, Honorable Kaluma. Yeah.
You're taking the responsibility of the chair.
It's only that he's a very recognizable face. Probably the first time I'm seeing it in person. Maybe I'm a bit too excited from it.
Yes, Honorable Kaluma.
My learned brother is aware we have boycotted courts today to be here. Yeah, but Chair, let me first start by commending the presentation made by Bowmans, Colson Honey LLP during this public participation. I've read through word by word. This is a 31-page, I think at font 8, this must be font 8 landscape. This is too detailed, and it is something that I register my gratitude on behalf of this committee and Parliament, for. Chair, as you rightly say, and as the team do confirm, this amendment bill is very critical. And the heart of is part process 40A, 40B, and you peruse it keenly. It is actually doing away with that entire part 3A. It is being, collapsed. And I'm saying this as a lawyer, now not as a member of Parliament. If you read through the proposed amendments against what is in part 3A, they are not minimal. It is a total rejection of that part of the bill, which is the very stem of this bill. So I wanted to hear from the very learned, counsels from this great firm, why we are, essentially not rendering mild, but deleting those provisions. That is generally, Chair. Chair, if you look at the proposals in terms of the amendments being preferred to the proposed new clause 40B, and the proposed new clause 40B is dealing with abuse of superior bargaining position. The presentation being made is actually protecting superior bargaining position. And I want to take the presenters, particularly to clause 40B, to, if you go to H, even in our legal profession, we have prohibitions against, charging fees below, some level. But here you are saying this one should be amended in the manner you propose. When you look at I, unreasonable collection or processing of data of a counterparty, unreasonableness, irrationality, in admin law have been defined. And to me, the definition we have of unreasonableness in law already incorporates the amendment you're proposing, to this clause. Then there is the matter of your proposal for deletion of subclause 5 of 40B, where you are saying, in fact, subclause 6, you are saying we should do away completely with criminal penalty. And we go, the bare minimum admin, penalties proposed. Is it at 91? 91, yeah, the admin proposed at 91A. Now, number one, this is a person who is already enjoying a superior bargaining position. If you leave it to him that he can just be punished by being required to, pay off or keeping to the civil realm, if it is money, they have it. So they'll continue breaching, they pay you. They already enjoy massive resources, and so if you give them the leeway that these things will just be sorted out, through civil procedures, I can tell you nothing much will happen. And if you look at the admin sanctions, just look at them. Written warning, is issuing discretion or power to the undertaking, imposing an admin penalty. these things cannot stop a person enjoying massive resources, a person enjoying superior bargaining positions, particularly when they are undermining the very stem of this law, the competition law. And so I wanted you to retract where you are proposing removal of penalty, so that at the very maximum, I thought you would propose non-custodial, kind of penalties or sentences, but not that we leave the idea of criminal, contravention culpability, and then we leave it just in the realm of the power play in the civil, normal ordinary civil processes, and all these admin penalties, which again will be subject to Article 47, fair administrative actions. It could be taking eternity granting those Article 47 and the Fair Administrative Action Act provisions, while a person is actually entrenching their superior bargaining position in the market and actually suffocating those of inferior bargaining position completely out of the market. I wanted to take your thoughts on those two and largely a reconsideration of the overall impact of your proposed amendments to that part 3, which to me is at the very heart of the amendments. I thank you, Chair.
I think the Honorable Kalumba's contribution is more of discussion on that. Maybe you can give us your quick reaction.
Thank you so much. So I'll touch on all the points you've raised. Our proposal on Section 3, specifically on abuse of buyer power, that it is taken out of the Act, is because these provisions are repeated under abuse of superior bargaining position. So the abuse of superior bargaining position is an umbrella term that covers not just buyer power, it covers all contractual relationships. So we think that it adequately deals with what the abuse of buyer power provisions are trying to catch. And that is why we're saying, and if you look at our proposals on the amendment, they're significantly the same, and materially the same because the laws are the same. And so we think that can be streamlined. We're not getting rid of abuse of buyer power because it will be dealt with under abuse of superior bargaining position. The second thing is that within our amendments, our proposals on the amendments of abuse of superior bargaining position, we actually think it's a good thing that we have this in our bill, but we do think that some work needs to be done within those provisions to make sure that we are not proposing a law that will have the effect of chilling legitimate commercial negotiations between parties who may not share the same bargaining position. As I'd said, in reality, there are no commercial negotiations. Very few happen between parties within similar bargaining positions. So the introduction of these provisions is good for those in a lower bargaining position, but it at the same time needs to be detailed enough such that it does not detract from the ability of parties to just do commerce. Because at the end of the day, parties can enter into the contracts that they want to enter into, and they should not be limited in that regard. So I think that's what our amendments are tailored towards. But we think the abuse of superior bargaining position provisions should be kept within the bill, just to make that clear. Touching on the criminal sanctions, I think the first thing is that in practice, we've seen that criminal penalties aren't even being utilized. They exist in certain provisions of the Principal Act already. And what we have seen in practice is that the authority will choose to use the penalty route. The authority has been active in enforcement, and they've been penalizing companies that are found to engage in certain anti-competitive behavior. So we think that the penalties, perhaps maybe they could be bolstered a little bit, but we think that they are sufficient to discourage parties from engaging in the conduct that is prohibited under the Act. We think criminal sanctions for contractual relationships are excessive. Because at the end of the day, it's a relationship based on commerce. It's a commercial relationship, and there's no in our view, there's no merit for a party to go to jail, of the risk of going to jail simply because their contract is skewed against the other parties. These are matters dealt with sufficiently under existing legislation and can be dealt with by the courts. And the CAK can also impose penalties. So we think all those three, or the existence of those existing remedies in law, are sufficient for purposes of these particular provisions, that the criminal sanctions be taken out of these specific provisions. Yeah. Cede the floor back to the chair.
Yeah. Chair, may I seek a small clarification? Can you look at 40BD, 40B2D?
40B2D?
2D of the bill.
Okay. Mm-hmm.
Unilateral variation of contractual terms, conditions, or other rules associated with the transaction or service without prior notice to the counterparties. Is this possible within the context of the contract law?
Yes.
You are taking us through? Can you unilaterally vary a contract? And if you do, why are you saying it should not be punished? Are you still operating under the contract?
It depends. I think it largely depends on the agreement between the parties, and a termination of the contract should be in line with what the contract states. Here, what we are trying to, I think what the bill is trying to cover is in these situations where, for instance, you sign up to an online agreement. So you've not had the opportunity to negotiate the contract. Up to those all the time. Terms and conditions that are agreed online, if you're contracting with, for instance, a digital player online, you're getting a digital service, you will sign up to the T's and C's and the online agreement. And I think that is the mischief I think the Act is trying to cover. It's not in the negotiated contracts. There are negotiated contracts and there are some that are not negotiated. I think even within the negotiated contracts, we have seen instances of parties unilaterally terminating contracts without reference to the counterparty or without reference to the contractual terms. And that is what we think should be expounded on, because there are various reasons for which a party might choose to unilaterally terminate a contract. And so it should not be a broad-based prohibition or a broad prohibition, but it should be qualified. It still exists, but we're just recommending that it is qualified in the manner that we have suggested within our amendments. So, yeah, unless you feel those amendments are insufficient to deal with the issue.
The ball now will be on your court, Honorable Kaluma. And I'm sure you're very excited. Wakili used the word broad-based. Thank you very much for your submissions. And we are really have thoroughly enjoyed the contributions you've made across. Took your time to read, research, and make very good presentation and borrow from best practice. Thank you very much.
Yeah, thank you for the opportunity.
Asante, Kenya Bankers.
Name is Arnold Wangila, Finance Manager at Kenya Bankers Association. I will allow my colleague to, at Kenya Bankers Association, I will allow my colleague to introduce herself and take us through the first bit of submission, and then I will take you through the second bit of submission. Thank you.
Competition Amendment Bill. Thank you, Honorable Chair. Good afternoon to the members of the committee. My name is Henda Anjichi. I am Regulatory Counsel at KCB and also representing Kenya Bankers Association. Like my colleague has said, we thank you for the opportunity to make our presentations. What we have submitted is a summary of our thoughts and our feedback on the Competition Amendment Bill. Very much like the previous stakeholders, we do believe that this bill is significant in terms of its impact in the business environment and in the economic market. Our submissions are also tying to what the previous stakeholders have submitted up on. Similarly, on regulatory overreach, conflicting regulatory concerns and compliance obligations presented by the proposals in the bill. We also believe that the market should have room for self-regulation and the freedom to actually commercially contract. And we also do believe that if some of the issues and proposals in the bill are not adequately addressed, then this may open up the market to unnecessary litigation and unnecessary regulatory overreach as well. So that is just in summation, some of our proposals. I will do my best to summarize the same for the betterment of in the interest of time. We will start with our proposed amendment on Clause 3, which speaks to Section 4 of the Act on strategic market position and superior bargaining position. In terms of summary of the provision, the clause adds two new concepts which have previously been spoken about: strategic market position, which looks at whether a person can influence prices, quality, service, output, or innovation in the market. Our proposal is that we do away with subsections 4 and 5 and replace the same and qualify the definition of how one may be determined to have a strategic market position. And our proposal is that strategic market position will only be possible where the authority establishes that a person has a substantial and durable market influence in a properly defined relevant market. The second proposal we are making is that when the authority assesses this strategic market position in a digital market, then the authority shall consider the relevant factors cumulatively and not one over the other, including network effects, access to data, switching costs, ability to multi-home, economies of scale, availability of suitable substitutes within the market, market contestability, and the importance of any intermediary service. We also propose that a proposal is an amendment.
Maybe before you proceed,
yes, Chair.
Quick one. How do you measure? How would the authority measure durable market influence? The durability of the market. How will the authority measure that?
That is something that we have seen in other markets being done, and it is a proposal we are making for the authority to consider.
Yeah, we are considering it. The question is, how do you measure? What do those other markets say is the gauge?
The gauge would be in terms of the market size and the goods and services that are provided within that market, and also the players within the market in terms of how the goods and services are provided.
Even as you attempt to respond to that, you realize that would be very difficult to measure. How do you measure the durability? You know, like it's now what could be a market leader now, in another few weeks there could be a major disruption that now would affect the durability. That I was when I saw that one, I was like, good idea, but then how would you measure the durability? Anyway, continue the rest of your submissions.
Thank you for those comments. In terms of also our other proposal is that a person shall not be considered to hold a strategic market position solely because his product or service is widely used, data enabled, or offered through a digital channel supported by network effects, or offered through a partnership or other commercial arrangement. In assessing market power, the authority shall consider all reasonably available alternatives, including regulated and unregulated providers, including also domestic and cross-border providers, formal and informal alternatives, and substitute products or services, both digital and non-digital channels available to consumers or users. A finding of strategic market position shall not by itself constitute a contravention of the Act. We are proposing that liability shall only arise where the person engages in conduct that materially restricts competition, market access, innovation, switching, or multi-homing or consumer choice. Conduct shall not be considered abusive or anti-competitive where it is objectively justified, proportionate, and reasonably necessary for legitimate commercial, technical, security, data protection, consumer protection, operational resilience, credit risk, prudential, AML, CTF sanctions, or for other regulatory purposes. The proposal here is just in recognition of how some markets or some industries are heavily regulated, and some of the conduct of these entities is actually informed by their own regulatory and compliance obligations. If I may move on. Clause 6, which is an amendment of Section 23 of the Act in terms of criteria for determining dominant market position. We propose to qualify this provision in the bill with a qualification that, provided that in assessing market power or significant market position in relation to a digital activity, the authority shall define the relevant market by reference to all reasonably available substitutes and competitive constraints, including regulated and unregulated providers, domestic cross-border providers, and all other alternatives, including digital or non-digital channels. The proposal here is just to enable and ensure that market power assessments reflect the actual competitive environment in which consumers make choices. We all know in digital markets, consumers may have access to a wide range of alternatives and including even offshore platforms, and substitute with either digital or non-digital channels for actually the goods that they may consume, whether in a digital market or not. So our proposal is that, or our thinking is that, without this clarification, the authority may risk assessing market power too narrowly by focusing only on domestic providers, and I think there should be room for other alternatives to be provided. We foresee a risk where this could overstate the position of regulated undertakings and result in findings that do not actually reflect consumer choice or even competitive pressure in the market. On to the section which Honorable Kaluma had some key concerns. This is Clause 9, which is Part 3A on unfair market conduct, and specifically Sections 40A, 40B, and 40C. We have made some proposals, and we see that this section or this clause introduces a new part on unfair market conduct, and it consolidates and expands the regulatory oversight on abuse of power, thereby providing a structured framework that combines substantive prohibitions, illustrative conduct, and sectoral regulation and enforcement mechanism. In our substantive submissions, we've just provided a summary currently. We are of the view that some of these provisions are already covered in the Principal Act, and to be able to actually intermarry the two, we would want to provide some qualifications to Part 3A, Section 40D, and provide an objective justification. In determining whether conduct constitutes unfair market conduct, abuse of buyer power, or abuse of superior bargaining position, the authority shall consider the commercial, contractual, and regulatory context of the conduct, including the nature of the relationship, availability of viable alternatives, material harm, transparency, contractual basis, objective justification, and any applicable legal, supervisory, or regulatory or contractual obligations. Lawful collection, use of processing data in accordance with the data protection law, contractual terms, consent, or other lawful basis shall not, without evidence of competitive material harm or abusive conduct, constitute unfair market conduct. I believe that qualification speaks to the issue of regulatory conflict between the the Office of the Data Protection Commissioner, and the fact that parties should be allowed to engage in legitimate business without having to necessarily fear regulatory overreach. We are also proposing graduated enforcement. For a first contravention, the authority shall issue a warning, a compliance direction, remedial notice, or other administrative measure unless the conduct is deliberate, repetitive, fraudulent, or causes substantial harm. Now, this is left to the determination of the authority, of course, in consideration of all the qualifications we have proposed as amendments. We are proposing, and we are also of the view that criminal prosecution is excessive, and our proposal is that it shall be reserved specifically for deliberate, repeated, or serious contraventions or willful failure to comply with a binding direction after a reasonable opportunity to either appeal, respond, or remedy the contravention has not been met. With respect to Clause 11, which is an amendment of Section 55 on false or misleading representation, the clause adds new grounds to the existing offense of false or misleading representation. We are proposing a proviso to Section 55, and that proviso is that, provided that where the good or service in question is a financial product or service regulated, then that products or service are prescribed by the financial regulator. Compliance with those disclosure requirements shall be a defense to a charge under this section without prejudice to the authority's power to refer the matter to the relevant regulator. The point here is that there are some entities and undertakings in the market that are already heavily regulated, and in their compliance obligations are required to make certain reports or certain disclosures to their primary regulators. And we see a risk of regulatory overreach or regulatory conflict in terms of compliance. So that is our proposal. This is with regards to the approach to financial consumer protection, particularly in light of the joint financial consumer protection framework that is currently being developed by financial sector regulators. We had also provided our comments on this financial consumer protection framework, and we had noted that the Office of the Data Protection Commissioner was not included, but we believe that some of these amendments will tie to the regulatory purpose of that financial consumer protection framework. The framework really addresses disclosure of fees, charges, product terms, which are issues of competition law, and we believe there should be some correlation to the same. With regards to Clause 13, which is an amendment of Section 89, in terms of failure to comply with an order, the clause adds a fine of up to 10% of a business's gross annual turnover for the previous year for failing to comply with a lawful order of the authority. We are proposing to revise this section, and our proposal is that a person who, specifically without reasonable cause, willfully fails to comply with a lawful order, direction, or decision of the authority within the compliance period specified in the order or direction does commit an offense. A person convicted, a person held liable under subsection 1 shall be liable to a fine not exceeding 1% of the undertaking's relevant turnover, or 100 million shillings, whichever is lower. For purposes of this section, relevant turnover means the turnover attributable to the goods or services directly affected by the conduct giving rise to the offense. An order, discretion, or decision issued under this Act shall specify a reasonable time period for compliance, which shall not be less than 30 days from the date of service, unless the authority gives written reasons that a shorter period is necessary to prevent serious and imminent harm to competition, consumer welfare, or public interest. A person served with an order, direction, or decision may appeal to the tribunal within 30 days of service. The filing of an appeal shall stay the obligation to comply with the order, direction, or decision until the appeal is determined, unless the tribunal, on application by the authority, orders otherwise on the grounds that a stay would cause serious and imminent harm to competition, consumer welfare, or public interest. In determining the appropriate penalty, the court or tribunal shall consider the nature, gravity, and extent of non-compliance, the duration of non-compliance, the actual or potential harm caused, whether the non-compliance was intentional, reckless, or negligent, or inadvertent, steps taken towards compliance, restitution, or remediation, cooperation with the authority, and any previous infringements. We are proposing this because the proposed penalty of 10% is already provided for in the Act for actual serious offenses, and it is our view that this penalty proposed in clause 13 is excessive. Our proposal also provides a clear appeal process, which we believe is important, and the proposed amendment also introduces clear compliance timelines, automatic stay, given the nature of the business environment that we operate in. And this amendment also still does preserve the authority's enforcement power while ensuring that sanctions are reserved for willful or an unjustified misconduct and not necessarily for normal commercial negotiations or arrangements. With respect to clause 14, which is a new section 91A on administrative enforcement action, the clause gives the authority separate powers to take administrative action for any breach of the Act, regulations or guidelines, notices or directions. We are proposing that the clause be replaced and substituted. Our proposal is that where the authority determines that a person has contravened the Act, the authority may take administrative enforcement action that is proportionate to the nature, seriousness, duration, and effect of the contravention. The authority may issue a notice or a written warning, issue a direction requiring the person to remedy the contravention within a specified period, impose an administrative penalty, similar to what we had proposed in the previous clause, suspend for a specified period a right or a privilege, where the suspension is related to the contravention, take any other administrative action. For purposes of this section, again, our proposal on the relevant turnover is stated. We propose this to further prevent double punishment by ensuring that the authority does not impose an administrative penalty, and we do not support criminal prosecution as well. So our comments also still stand. With respect to clause 12 on consumer welfare, this clause broadens the authority's powers regarding consumer welfare matters. Section 70A of the Principal Act is amended to delete the word complaints and substituting thereof with the words consumer welfare. We are proposing that, that there should be coordination between the authorities and other relevant sector regulators for reasons we have already stated. And this is to ensure that consumer protection issues, especially in heavily regulated sectors such as banking, telecommunications, insurance, and capital markets, which are often subject to oversight by both the authority and other regulators, are actually coordinated well to avoid issues of cross-purpose determinations by the different regulators. Requiring consultation and coordination between the regulators would promote regulatory coherence, improve enforcement efficiency, and provide greater certainty to market participants. It would also ensure that sector-specific expertise and regulatory considerations are appropriately taken into account when addressing consumer welfare concerns. With respect to the turnover-based penalties, we recognize that the clause introduces a more stringent penalty framework by the authority by linking administrative fines directly to an undertaking's gross annual turnover. While turnover-based penalties may serve as an effective deterrent against anti-competitive conduct, their application could result in significant financial exposure, irrespective of the actual level of consumer harm or the market impact. So our proposal is that when determining the appropriate penalty, the authority should take into account all the relevant and aggravating and mitigating factors, including the nature, gravity, and extent of the infringement, the actual or potential harm caused to consumers and the competitive environment, the duration of the contravention, the undertaking's degree of intent or negligence, and any cooperation provided during investigations or notices or any other administrative process, including steps taken to seize the conduct and remediate its effects. So this just gives undertakings the opportunity to correct and self-regulate rather than having very steep penalties or criminal sanctions against such behavior that may be corrected through market conduct itself or self-regulation. We believe this would encourage proactive compliance and actual cooperation between entities and the authority itself, and timely remediation of any identified concerns, ultimately supporting both effective enforcement and a stable business environment. With respect to clause 14 as well, section 91B, we are proposing procedural safeguards. Our proposal is that before the authority takes any administrative enforcement action, the authority should issue a written notice to the affected undertakings stating the alleged contravention, the evidence and legal basis relied upon, the proposed enforcement action or penalties, and the period in which the person may respond. We believe this may also be tackled through regulations, but we just wanted to put this forward so that any amendments in the bill are also married to the parent act. The affected person shall also be given reasonable access to the evidence relied upon by the authority, subject to confidentiality, data protection, and legal privilege requirements. The affected person shall be given a reasonable opportunity to make written presentations, and where material penalty or remedies proposed, oral presentations. The authorities shall also be required to issue its final decision in writing within a reasonable period. And we also propose that the filing of an appeal shall stay enforcement of the decision pending determination of the appeal unless the authority determines that a stay would cause serious or imminent harm to competition or public interest. Thank you.
Thank you, Chair. I don't know, with your guidance, do we also present on the microfinance bill, or we take questions first, then we...
Are there concerns from members? Honorable Kaluma. Make it direct to the point, please.
Yeah, Chair. I'm very happy with the presentation on the competition amendment bill because unlike the previous ones, this one is sustaining the provisions which are at the heart of the bill while seeking legitimate improvements. But I wanted to look at, I wanted to get clarification on what you're proposing as amendments to clause 91A. You see, looking at your presentation, is it your position that the administrative enforcement acceptable here should be limited to suspension so that you cannot revoke or vary any right, benefits, or privileges granted under the Act?
Sorry,
so looking at your amendment,
yes.
You are only talking about suspending in terms of how you propose 91(2)(d) to be amended.
We have also proposed a penalty or rather an amendment to the proposed penalty. I don't know if I'm looking at the same section that you're looking at.
No. I'm looking at, the proposed new 91A. 91A at page 76. You've amended D, and what proposing is only. You can see it.
Yes, Honorable Member, I've seen it.
Yeah, and I'm asking why you are excluding revoking or varying any right.
I see the direction of your question.
Yes.
Our proposal is also to allow for conduct to be corrected within contractual negotiations or commercial negotiations. This is because whichever entity may be held liable, the conduct we are presuming here would actually affect other parties. And so that is why we are proposing a suspension to allow for correction of the harm, which is something that should be possible in the market.
Yeah, not complete revocation
Yeah.
or variation. So I get you, that will be considered. Then lastly, look at 91A, what you are proposing in terms of your piece as a new proviso or subclause 4. The authority shall not impose an administrative penalty under this section and support criminal prosecution under section 89 in respect of the same conduct and the provision starts with the words without prejudice to any other provision of this act. If you look at the proposed new section 91A, you are seeing it?
Yes.
Without prejudice to any other provision. Now you are negativing that by this clause. You are saying that there should be a choice on the part of the authority. It is either
Yes.
What is your basis for that? Because the fear with criminal processes, again, you can be in court for as long as the courts grant you time. A day like today, advocates are boycotted, you and I. So you can be there for, what is the period of time within which we conclude criminal cases? Some go up to 10 years.
Yes.
So during those 10 years, you are saying, administratively, the authority cannot even, proffer some measures which, if undertaken by the defaulting party, can be part of the mitigating, factors you are enumerating in subclause 7.
We have taken consideration of your comments.
Yeah, thank you.
Yeah.
Thank you very much, Kenya Bankers, for your very candid presentation. Again, you raised very valid points on judicial overreach, on market, on definition of strategic significance, on market power, and all those concerns. They are valid, and we shall do the best we can to consider them during our report writing. The next presentation on microfinance bill.
Yeah, thank you, Chair. We do recognize the objectives and the reasons for the bill to replace the current act, but we have two issues that we want to bring.
And perhaps Kenya Bankers, just hold on. Ms. Vela Kedogo Kigwiru, we recognize you. You'll be heard next after the Kenya Bankers presentation. We can't hear you. Taran. You have to. You have muted from your ends. Vela, you have to unmute yourself. Okay, proceed. Please tell her to unmute herself, and it's not. She seems to be presenting already. It's not her time yet.
Thank you, Chair. Just as a way of introduction, we do recognize the objectives and the reason for these amendments. However, we will want to bring to the attention of this committee two items. One is on that proposes to increase the core capital to 250 million from the current 60 million. That is through Schedule 1 of the bill. Our proposal is the move from 60 million to 250 million is a bit steep, and we recommend that we have a moderate increase of between 100 million to 150 million to be achieved within the proposed 5 years. And this is because most of the microfinance banks serve a specified niche, and therefore the shareholders may not have the muscle to raise this capital of 250 million. But if we can moderately increase from the current 60 million to 150 million, then most of them will be able to still serve the market that they established to serve, considering the current profitability challenges, the current, of course, bad debts that eat into their capital. So our recommendation is the committee considers to reduce the current proposal of 250 million and put a figure of between 100 to 150 million, retaining the 5-year grace period. Then the second proposal is on clause 58.1 that seeks to prohibit non-deposit taking microfinance banks from receiving deposits or cash collateral. Chair, we seek that the committee considers to retain the proposal with an amendment to allow some of the non-deposit taking microfinance banks to receive cash as collateral because the markets they serve, especially for like chamas, the only collateral they may have is cash. But of course, put preservations in terms of then that cash cannot be used by the microfinance bank for purposes of onward lending or doing investment, and specifically be held for that purpose of collateral. And where then the borrower manages to clear their obligation, then the bank should be able to refund those monies to the customer. So we are not suggesting that the entire proposal be deleted, but have an amendment and safeguard such that where cash is taken as collateral, then the bank doesn't benefit or transact with it, but hold it for the purpose of which it has accepted that cash. The same way, if it takes a car as collateral, then it should be viewed in the same way it takes cash as collateral, and that cash then should not form part of its working capital or its investment portfolio.
Thank you very much, and I think your submissions on the reduction of capital requirement from 250 million, you seem to be opening up to the revision of the capital requirements we did for banks. I think that's why Munawatetea ndio.
Yeah, we have also, Chair, experienced some of members have experienced the challenges of the laws that went through in terms of the core capital for banks. So we are also speaking from the experience from this other side.
So thank you very much for your submissions. Pass our regards to the Chair and the CEO, and all the best.
Thank you, Chair.
Our last presenter for the day is Ms. Vela, who has joined us online. Are you able to hear us now? Okay, second last.
Okay. Can you hear me now?
Yes, we now can. Introduce yourself and take us through your submissions.
Okay, thank you so much. My name is Dr. Vena Kedogo Kigwiro. I'm an advocate of the High Court of Kenya, and I'm also a postdoctoral research at the Job International Relations, actually for politics at the Technical University of Munich. So I'll be presenting this presentation from Munich. And thank you so much, honorable members of parliament and the chair of the finance committee for giving me this opportunity. So allow me to share my screen. Let me know if you can see the screen.
Yes, we can.
So I would like to set the background and to bring to your attention that the amendment of the Kenyan Competition Act to introduce provisions that seek to regulate digital markets is not happening in a vacuum. It's happening at the global level. So for this presentation, I will draw from both domestic, regional, and global developments to be able to inform to what extent the amendments should be adopted and not adopted. So for instance, at the global level, although there's a consensus that the digital markets present unique characteristics such as network effects, multi-sided markets, digital ecosystem, there's a debate of whether we should have a separate ex-ante legislation or use the existing export legislation, in this case, the competition law, to be able to regulate these markets. And in the case of Kenya, as you've seen, we are not introducing a new law, but we are going to use our Kenyan Competition Act to be able to regulate digital markets. But other pertinent questions arise, such as whether our competition law is insufficient, whether this competition, whether we should investigate digital markets under the abuse of dominant provisions, and whether Kenya is also taking into account the global development and the geopolitics of competition from key powers such as the United States, the European Union, and China in making these amendments. And so far, there are so many countries that instead of having a regulation that is ex ante, like the EU Digital Markets Act, they have decided to amend their laws. Others have just decided to take a wait and see approach to allow their markets to develop in order not to stifle innovation in these markets. And there's also been a lot of backlash also from domestic actors, which have argued that the domestic markets are vibrant and therefore there is no need of introducing additional provisions to regulate digital markets. So with this background, some of the fundamental questions that I would like the members of parliament to ask include, is there market failure in our Kenyan digital markets? Is our competition law insufficient to address the concerns in digital markets? And most important is that Kenya already has placed itself as a leader in global competitiveness in digital trade, and therefore we need to also ensure that we enhance innovation, investment, and international cooperation with other participants in this market. And another very important question is how these amendments align with the FCFTA and COMESA, because Kenya is a member state to this. So you'll allow me to now make my amendments on clause 2 of the bill on definition of terms, clause 3 that deals with the issue of strategic market position and superior bargaining position, and clause 7 on the introduction of a superior bargaining position. My former colleagues have been able to address some of these issues, so I will not repeat the same things that they have indicated. On the definition of digital activity, which is defined as the provision of a service to the internet or the provision of digital content, whether for consideration or otherwise, and whether such activity is multi-sided, I find this definition to be extremely broad, although flexible. It's broad in the sense that it might be able to address some of the digital activities that really need not to be regulated at this moment. And as you can see, this definition is borrowed from Article 3.1 of the UK Digital Market Competition and Consumer Protection Act. But when you look at this section, it also indicates that any other activity that is carried out for the purposes of the internet or digital activities will include a combination of the internet and the electronic communication service. And that's why in this case, if I give a reference to Safaricom, we would like to know whether services that are being provided through electronic communication service and not through the internet, such as M-Pesa, will also constitute a digital activity. So from this definition, we realize that there is no inclusion of the issue of electronic communication service, whether it will constitute a digital activity. And also there's differences between how Kenya is defining activities through the internet as compared to the FCFTA and the 2025 COMESA Competition and Consumer Protection Regulation, which apply to designated or platform service. So digital activity is extremely broad and could lead to over-enforcement. And also there's no specific boundaries in determining which specific internet service or digital activity will constitute digital activity. In the case of the European Union, which applies to core platform services, the distinction is extremely narrow to ensure that the kind of the digital service or product we are trying to regulate is only one that enables business users to reach end users and they facilitate commercial or professional transactions. And in the EU, technology companies such as Meta, Alphabet have successfully contested some of their services to be included as core platform services by the EU Commission. And also, under the enforcement of the UK Digital Market Competition and Consumer Protection Act, tech companies have raised issues indicating that services that fall under business-to-business infrastructure do not constitute a digital activity. And with this international experience, I would like the Competition Authority of Kenya to look into how they define a digital activity so that the digital activity is not too broad to lead to over-enforcement. So my recommendation is that we need to revise the definition of digital activity and provide information on how digital activities will be delineated when a single undertaking that provides multiple services in an integrated way will constitute a single or a distinct digital activity. For instance, when you look at Meta, it provides different services such as Facebook, Instagram, WhatsApp. How do you differentiate these services that are provided by one undertaking in an integrated way and limit the definition of digital activity to the business-consumer relationship that lead to a commercial or professional relationship? Another clause under clause 2 is how the Kenyan Competition Amendment Bill categorizes which services will fall under digital activities, which is heavily borrowed from Article 2 of the EU DMA, which identifies these services as core platform services. Kenya identifies them as digital activity. And when you look at Article 2.2 of the EU DMA, they define what will constitute an online search engine and online social networking services. And the question is whether Kenya will have an implementing regulation that will be able to differentiate these services in accordance with their functionalities and characteristics. For example, under the EU DMA, online social networking services are only those digital services that enhance community interaction like Facebook, TikTok, and so on. And there's a lot of emerging cases where tech companies have been able also to successfully contest that there was a wrong categorization of. So my recommendation is that this section should be removed and it should be moved to an implementing legislation. So with this, we realize that we also have other definitions if we have this, that the digital activities as defined will cause a lot of confusion and legal uncertainty among business community. It will lead to a lot of legal disputes. So there's a need to literally have a clear definition of digital activity. On clause 2, also the definition of digital markets and the definition of intermediation service, we should have clarity on whether services offered through telecommunication constitute digital markets, and also the question of whether the definition of intermediation transaction will also apply to the definition of online mediation services. Under clause 3, where my colleagues have said a lot, and therefore I will not repeat, the definitions of these terms are very critical. For example, as others have pointed out, the definition of strategic market position reflects the definition of dominance under competition law or market power. So the question is, why are we introducing a provision that is very similar to the other provision? I think when you look at superior bargaining position and buyer power, there's some similarities on what constitutes buyer power in superior bargaining position. So in this case, the competition bill goes ahead under section 4.5 to introduce this provision and provide factors that CK will consider when assessing or determining whether an undertaking has a strategic market position. And one of the honorable members of the House has asked, how do we determine a strategic market position? How do we indicate that a digital platform has an entrenched power? And when you look at these provisions, we have some issues that I think are important to consider. Will the strategic market position apply only to digital markets or digital activities? Because all these factors that are being considered here, network effects, economies of scale, apply to the characteristics of digital markets. Secondly, it also fails to define what will constitute a strategic market position, but only goes ahead to tell us how CK will determine whether a provider of an internet services has a strategic market position. And finally, there is no quantitative threshold to be considered when determining a strategic market position. And this feeds into the question, how do we determine that a technology company or an entity that is providing a digital activity has a strategic market position? And that's a question that has been asked. So my recommendation is we need to define what constitutes a strategic market position in digital markets, especially as it relates to global technology companies, because this introduction of digital market provisions will not only apply to domestic tech companies in Kenya, but global technology companies as well. And also, we have to also understand, like when it comes to digital activities, will we investigate them under restrictive trade practices under Article 21 or Article 24 on abuse of dominance or abuse of buyer power or strategic superior bargaining position? Or Kenya would alternatively, borrowing from what COMESA and the FCFT has done, introduce specific prohibited practices by undertakings that have a strategic market position as they apply to digital markets. Some of this conduct is very different from what we observe in the traditional market. For instance, self-preference in imposing and steering provisions, data combination, imposing differentiated terms of prices to SMEs and international business. All these are very unique to the digital market. And also, as Uganda has done it, is whether when determining the factors that constitute a strategic market position, they will also be applied to when an undertaking has a dominant position. And therefore, I find it very important to amend Section 4.5 of the bill and introduce the issue of how Kenya will determine an undertaking that has a dominant position by using the factors that have been considered here. So maybe you want to know how can we determine this. So at the European level, they use turnovers, global turnover, EU turnover. I think to show that indeed an undertaking has a strategic position of significance, they look at the number of users individual users, consumers, and also businesses, which we can see Kenya tries to incorporate it under Section E of the amendment. So this is some of the ways you can determine whether it has an entrenched power. The UK goes ahead and looks at, does it have a link to the United Kingdom? And a link to the United Kingdom looks at how many users are on this platform. Let's think about TikTok. Can we say that if we have so many Kenyan users and so many business users on this platform, we would argue that it has a link on the Kenyan market, especially for tech companies that do not have physical presence in the country, and also substantial and entrenched market power and position. So the same question that you are asking, how do we determine that it has an entrenched market power? We can use the turnover, the global turnover, the Kenyan turnover as applied in the UK. I'm not saying we copy-paste this. I'm just trying to say these are some of the global developments that can inform, because this is not only a new area, but it is also very complex. And the kind of litigation that are coming from the European Union and UK will show you that business are ready to defend some of the issues that were wrongly included in this digital market competition regulation, and also where the Commission does so. And very importantly, on clause 7, which I'll make some amendments, is I didn't really see the clear differences between these two provisions, abuse of buyer power and abuse of superior bargaining position. And when a business is being investigated, where exactly how will businesses be able to understand that their conduct is under abuse of buyer power or abuse of superior bargaining position? I'd like to understand from the Competition Authority of Kenya why they introduced the abuse of superior bargaining position. Was it to address issues that pertain digital markets? And even if it was about digital markets, only Section H would speak into digital market regulations when it comes to the issue of combination of personal data and public data. So this clause 7, for me, it brings a lot of issues. It's introducing concepts that are interrelated, creating confusion in the interpretation and application, and it's also not clear on how we shall be able to determine the subject market position. And also, in this case, like the Competition Authority of Kenya has a department on abuse of buyer power. Where exactly are these sections falling? And therefore, my key recommendation, which is very important, is that at the core of this amendment, we should be able to know that this amendment is not to protect competitors, but to enhance innovation and business environment in a country that has positioned itself as the Silicon Valley of Africa, and in which it has sought to also develop its digital economies, and also in compliance with the FCFTA protocol on digital trade. We need a market-wide digital market inquiry that will be undertaken by the CK. In the recent review of the OECD, some of the stakeholders indicated clearly that the information on how these amendments were done. We only have one market inquiry, but a market-wide digital market inquiry that clearly tells us that in the fintech sector, these are the competition issues. CK has not been able to address this. The law is insufficient, and therefore we need to introduce these provisions. And then there's a need to reassess the definition of times, to have clarity on how the provision of abuse of dominance, superior bargaining position, and buyer power will interact, and importantly, being a member of COMESA and the FCFTA, be able to show how these amendments will align with the COMESA and the FCFTA competition. And the clarity on which prohibited conduct will apply to digital markets, taking into consideration their unique characteristics. And also, so the issue of digital mergers has not been addressed under the COMESA competition regulations. Mergers that do not meet the merger threshold may be assessed by the Commission when it considers the transaction value. Are those things that the Competition Authority of Kenya would like to do? And most importantly, I think there's a need to establish a digital markets unit at the Competition Authority of Kenya to start doing some of these higher studies to be able to inform a very appropriate competition law. And very important, the need to adapt to international practices and experiences on how they've been able to include these provisions, and the contestations that comes from enforcement of these provisions becomes critical for the Competition Authority of Kenya and Kenya at large. Thank you so much for this opportunity, and I appreciate it.
Thank you very much, Daktari, for your very, very good and comprehensive presentation. Are there concerns from members? I think your presentation was very straightforward, and most of the issues that you have raised had been covered earlier, but you raised very fundamental and critical questions as to, especially on the definition of digital place and whether that should fall under the Competition Act, or whether that particular amendment then should sit in a different amendment or a different statute rather than in the competition law. And I think the example you've used of TikTok is a very live example, and thank you. We thank you very much, and also for taking your time. Why is that? Is that in Zurich? Munich. You're in Munich.
Munich, at the Tech University of Munich in Germany.
Oh, very good. Thank you very much, even taking your time to make a presentation. Thank you very much. Honorable Kaluma, you have something to say?
Thank you.
No, I just wanted to thank her, as you have done, Chair. This is Dr. Vela Kigwiri for the beautiful and learned presentations. Vela, I also want to thank you for, joining this public participation process, which is a process, entrenched in our constitution, even from outside of the country. I've been enriched, Chair, by the comparative analysis between these provisions and indeed the provisions in more developed jurisdictions like the UK and Europe. I thank you, and I would be glad if you joined other engagements where, as your representatives, you are thinking of these laws we are making for the better governance of our country. Thank you very much.
Thank you, Honorable Kaluma. CPA Ruto.
Thank you. Let me also join my colleagues to thank Daktari for creating our time and to participate in this noble process that is provided by our Constitution, so that everyone's views and opinion and such healthy contribution and aid that you've made. Chair, as we proceed to discuss on this particular amendment on Competition Authority Bill, with the current dynamics in the business environment, digital platforms seem to be taking over the space, especially between the counter space that we used to have for service delivery, where you work in for service or for commodity or so in terms of business. But then, if we want to divorce this SACA, this particular agency that is monitoring the business environment because of the nature of business that is coming up with the digital space like TikTok you've mentioned and many other platforms, then who will ensure that this space is fairly operative well, that it protects the players? Because I'm sure every other business would want to utilize the same platform. If we don't give this agency powers in this law, who then will do it? If we want to regulate digital, of course, we have the Digital Users Act, we have the CBK, we have all this. But when the aspect of doing business is being abused, who will do it? I think that is the biggest question I would wish to get from Daktari and probably from knowledge outside there.
Fantastic. You may conclude, make your concluding comments, Daktari. And please share your PowerPoint presentation with us as well. We have your word presentation, but share your PowerPoint presentation as well.
I'm sorry, I missed the question. Can you just repeat it in one sentence?
Kaluma was just making a comment. I'm just asking, as from your contribution, you're trying to bring out the aspect of saying markets are changing. Now we are in the digital world, and probably the laws that are governing this regulation should be left specifically with the body mandated to oversight it directly. But I'm asking this agency called Competition Authority of Kenya, with absolute mandate of ensuring that this level play field that is fair for business to traverse. So then if we don't give powers, especially with the changing business world, to ensure and protect that space of doing business in a good way, in best practices, in an environment that each and every competitor or every trader or every business person can move on without being obstruction. How then are we going to see this? Because if we leave digital world to be oversighted by the Digital Act and authority that have been established, what will be the role of competition authority? I think that's what I'm asking. Where is the balance for that purpose?
Okay, thank you so much. So the first thing to do is to first understand the Kenyan market digital ecosystem and landscape by identifying who are the key participants in specific markets. Let's take one of a market like fintech or e-commerce. And in e-commerce, the Competition Authority of Kenya will be able to understand, do we have global tech companies in e-commerce? Like Amazon is not operating here, but Alibaba is operating. And we also have regional tech platforms like Jumia, Konga, coming all the way from Nigeria and operating in this market. And then now we have our own tech company, our own e-commerce platforms. Or a good example will be in the gig economy, which I did some consultancy for GIZ on this issue of Uber, Bolt, Farasi, Little Cab, and so on. So that's why I'm saying before introducing novel competition provisions, we must first understand the competitive dynamics. For example, when we look at the transport sector, the e-riding hailing up market where Uber and Bolt, I can't say dominating because that means another interpretation, but they're leading. And in this case, you realize that when new platforms like Farasi try to enter into this market, the reason they're not able to, they can enter, but they cannot expand and participate the way Bolt and Uber are operating. Why? Because of the network effects in this market, which leads to consumers being locked on one platform. Network effects simply means that the more a platform, the value of a platform increases with the users on those platforms. So drivers would want to be on Uber because most of the consumers or the riders and most of the consumers are on Uber or they're on Bolt. So very few people are on Yegu. So they get locked onto that platform in order to be able to access the consumers on that platform. And therefore, when a new platform wants to enter into the market, it can't enter because one, it can't compete for the users, it can't compete for the drivers. And when this happens, and that is what the abuse of economic dependency comes in, or abuse of superior bargaining comes in, then the platform, which has become so important because drivers are economically dependent on this platform. That is where they get most of their money. They can engage in whatever unilateral conduct they want, like delisting the drivers, giving users discounts and not compensating the drivers because they have that power. And that's the question I'm asking. Can we define that power or a platform that is able to enhance lock-in effects as a strategic market position? So the first thing is to understand the market, determine where there is a market failure, and also to look at how domestic businesses and international businesses in specific sectors interact with each other through analysis of the trading agreements they have. For example, in the hotel industry, where we have Booking.com. Booking.com may not have a physical office in Kenya, but most of the consumers from Europe, US, or not will use Booking.com first to determine whether they're able to find accommodation or not. But for you to operate on Booking.com, if you look at the South African Competition Commission market inquiry into online intermediation platform, is that for you to be able to operate on Booking.com, you have to be, there's issues of being ranked. The first person that appears on the first page will be able to attract consumers. But for you to be there, the commissions that Booking.com asks you to pay, or there's money that Google on its search market asks businesses to pay, or on Google Map, where most of the African businesses are trying to penetrate the market through this app. Because they don't have the capital, they don't have the muscle to be able to pay for this kind of appearance, this kind of visibility, ranking on these platforms, what the South African has done is that it has required this international platform that provide access to this core infrastructure to have what we call organic search. Organic search and paid search results happen where, for paid search results, you pay for clicks to appear on the first page. So, for example, you want to search for a flight to come to Munich, the first airlines that will appear. Or you want to search for a flight to go to Kenya and you realize that KQ is not even appearing on the first search results, or any other African alternative. So you find you're having KLM, Lufthansa, and so on. So as a user, you click on the first one. So for the South African, this is what they said. When somebody is making a search about South Africa, let them appear on the organic search. For organic search, you don't need to pay. It appears because the user has made that preference to look for African flights or do so. So that's the question we are asking. Is there a market-wide inquiry that specifically tells us these are the issues? Once we identify and we realize that, oh my God, there's a lot of self-preferencing. Self-preferencing occurs whereby a platform is also offering the same services as the business users on that platform. So it will rank its services higher than the other ones, giving its services its own visibility. Are we able to observe this in this market to say self-preferencing is prohibited? Are we able to observe that when businesses are operating on food, food delivery platforms, from the inquiry that CAK did, what were the exact competition concerns in this market? Once we are able to do that, then we are able to come up with solutions. For example, one of the biggest issues that has been going on at the global level is the issue of interoperability, asking Google to allow other platforms to operate on their market. And COMESA has initiated an investigation into Meta AI. So you see, when you're using your WhatsApp chatbot, there's only Meta AI. And the question is whether we should allow other AI-driven chatbots to be there. And what is the security and privacy concerns that come there? Once we are part of the global conversation, we are learning from the contestants that are coming from the global conversation, and we agree that Google, Android, and what has opened the market in Africa. How do we bring all these stakeholders to be able to address these issues? And for me, that is exactly what is missing from these amendments. I can see there's some provisions that are coming from the UK, from the EU. There's a confusion between what is a digital activity and a core platform service, and then you are just picking what is Article 2, putting it there. Those definitions, if you look at the legislation, the EU Digital Markets Act, those definitions have been highly contested. I just wrote a white paper for the Technical University of Munich, which is live, whereby we see TikTok in itself, according to the definition and categorization of core platform services, can be a video sharing platform. But the EU Commission said it's not a video sharing platform. It was primarily established to be a video sharing platform, but it is an online social networking service. But do you know why that categorization is important? It's because the obligations that apply to every categorization of our core platform services differ. Some of them, like on online social networking services, their obligations go beyond interoperability. They're extremely strict than the other services. So we really need to understand how these things are going to be able to come up with a regulation that will enhance business operations in Kenya, position Kenya as the said Silicon Valley. Other countries are also competing for this in Ghana, Nigeria, South Africa. How does Kenya position itself to ensure that we can open up our digital economy, our digital trade, and still take into consideration the preferences of the big powers, the US. The US is against this. EU, what have been the issues that have come from the implementation of the EU digital markets? What have been the opportunities? What have been the constraints? How can we learn from this? Because these amendments are not only going to regulate Kenyan domestic companies, other international companies from China, US, and EU are going to be regulated under this. Thank you so much.
Thank you very much for your very, very good presentation. It's very rare for Honorable Kaluma to clap for stakeholder, so must have really moved him. So thank you very much.
Return to Kenya when you are done with your study.
I'm already done with my studies. I already have a PhD already in competition law, yeah. But I'm always available to contribute to the Kenyan ecosystem with all the knowledge I've amassed over the years here.
Thank you very much, and congratulations, Daktari. Our last presenter of the day is Amphi.
Good afternoon, Chair and members of the committee.
Yes, good afternoon. Introduce yourself and take us through your submissions.
Very well, thank you, Chair. My name is Kimathi Kamenchu. I'd like my colleague to introduce himself.
My name is Edwin Morioki.
Thank you very much. Chair, we come from the firm of Musemi and Company, and we appear here on behalf of AMFI. That's the Association of Microfinance Institutions in Kenya. We realize that we seem not to have had sufficient copies of our submission, and Chair, it's to apologize. It's on account of the late notice. We only here for that purpose. Chair,
because the Secretariat Enforcement was telling me as well. Was received on Monday.
Yeah.
Communicate and perhaps follow on why the stakeholders this time around are fewer, because maybe they didn't receive their communications on time. Proceed.
Thank you. The Association of Microfinance Institutions. This is our chair is Mr. George Mbira, and our
chair. Did I hear Mr. Sunguya from Kajiado? I don't know. We have one Honorable Sunguya, who is a member of this committee, so probably you need to...
my apologies.
You need to separate the two Sunguyas.
Oh, sorry. I think the similarity, I believe this is CPA Ruto, if I'm not wrong. Yes, my apologies. I think the similarity got me a bit confused. My apologies, Mheshimiwa. Yes, Sunguya is here, but of course, CPA Ruto, yourself, Chair, and my learned senior, Mr. Opondo Kaluma, who seems to have departed right now. You're very well, Chair. Chair, we have our submissions that are before you, and even as we commence with that, we would like to highlight that these submissions are on the basis of 20 years of experience of an act called the Microfinance Act of 2006. We as a firm, Musemi and Company, together with AMFI, have had the privilege of being involved right from the inception of the Act in 2006 to where we are currently. A few highlights, Chair, even as we commence to make our comments. First of all, Chair, is to note that the expectation from the industry is that credence will be given to the place that microfinance has been given in the BETA economic transformational network, that microfinance is an access to credit question, and innovations from the perspective that comments that are being made are in light of the fact that we have had 20 years of experience and looking to see whether the new bill that is proposed, the 2026 bill, whether that bill actually meets the high expectation. Chair, the areas in which we will be commenting are in respect to the different parts that this bill has. First of all, the delineation of the different subsectors within the microfinance sector. Secondly, enhancement of clarity on licensing so as to ensure that the CBK is elaborating on a framework that has already been set out. Thirdly, the optimization of operational realities for microfinance banks, including single borrower limits, and then establishing the right fit for microfinance institutions, and finally, elaboration of transitional provisions, including the utilization of timelines that have been provided. Chair, as we go into the detailed comments, because what we have provided is a set of comments that highlight the proposed provisions, the provisions that were in the or are in the current act, and then thirdly, the recommendations from the Association of Microfinance Institutions. We would like to make 3 points, Chair. First of all, for microfinance, as I did mention earlier, access is an important thing. Access to credit is an important thing. And I would want to make the statement, Chair, that in this area of microfinance, unfortunately, we who are the leader in our region, the Eastern African region, have lagged behind when compared to the other nations in the region in terms of an enabling legislative framework. Highlighting examples from Uganda. In Uganda, they actually have a separate authority overseeing microfinance institutions. Sorry, Chair, did you want to make an interjection?
You've got 36, you have 16 pages of very substantial, substantive amendments you're seeking.
Yes, yes.
So if you go that direction, you may not get to the, because now we at lawmaking now, what we need to do is go clause by clause. Convince us why you think the amendments you're proposing are important. So please start from page 3.
Okay, very well, Chair. Not a problem.
Chair, maybe since you have started something that you wanted to make comparative, just to finish on that, where you mentioned something about Uganda.
Yes.
Vis-a-vis our case where Central Bank of Kenya is seeking to.
Okay. Yes, indeed, Chair. The point
make your case on having a separate regulator for microfinance.